with reports from Monday, and that is important because any early bills need to get reported out today. And we have one early bill on the schedule for today that I think we can take care of pretty easily. So we'll do that early this morning so we can get the report done and out on that. But I think, talking to Representative Cornell, we wanted to caucus both sides for a few minutes. So we will go into caucus briefly before we start voting on the bills. Thank you. Back. And we're going to see if we can put the exec session on speed dial. And the first bill we will bring up is House Bill 763. And I call on Representative Dry. I think you have a motion.
Yep, we'll start with the motion for ought to pass.
Thank you. Is there a second?
I'll second that.
Thank you. And Representative Dry, would you have a further discussion on that?
Yes.
And an
Like,
amendment possible?
I would like to make a motion to adopt amendment number 0743H.
Is there a second? Representative Morse. Representative Dry, would you like to speak to your amendment?
This is a very simple amendment. It just kind of tightens things up. One, we discussed whether we should include charter schools in this because they needed to be mentioned specifically if we wanted to include public schools. But on the advice of my chairman, the charter schools don't have athletic fields. This is about AEDs and athletic fields. If we find that this is a problem down the road, it's easy to amend. But at this point, it seemed extraneous. What we really wanted to talk about is the bill itself said that the AEDs should be readily accessible at each athletic event or venue, and talked about places where they might be maybe 4 soccer fields together. Does that mean 4 AEDs, or is one enough for that? And what we did is look back in the guidelines from the American Heart Association, for example, say when you're doing an AED plan for having something within a 3 to 5 minute walk. Try to do the best you can to get as much coverage as you can. And it really, so we don't need to put that in statute. What we need to do is say we're going to we're going to refer to the guidelines, and we changed it from at each venue is they will be readily accessible to each venue. So the AEDs in the area, it's easy to go from one field to the other, but we're not mandating that we have an AED on every field physically. And I think we can try to, that's the intent of the bill, is to make it as safe as possible without going really into the weeds in the statute. So I think this covers that very well.
Thank you. Representative Morse, did you have a further comment?
No, I agree with everything.
Thank you.
She said.
Any further discussion on the amendment? Seeing none. Madam Clerk?
Vice Chairman Noble.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Balboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
And Chairman Cordelli.
Yes.
17 yeas, 0 nays.
And would the clerk have a further motion on the bill?
I would like to move ought to pass with amendment.
Great, thank you. Is there a second on the OTP? Representative Woodcock. Any further discussion? Yeah, we're down one. Yeah.
Wait, what? Hold up. What was the amendment number?
0743H.
Okay.
Yep.
No, 17-0.
Yes, on the amendment, yeah. So we have a motion, OTPA. Did we have a second?
I'll second that.
Oh, Representative
no,
Woodcock. Yes,
Oh,
thank you.
I'm sorry.
Yep.
Yeah. Any further discussion on the OTPA for the bill? Seeing none? Whenever you're ready.
Vice Chairman Noble.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Balboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Representative Cordelli.
Yes.
17 yeas, 0 nays.
Thank you very much. Is consent okay with that?
Yes.
Great, thank you. Next, we had a subcommittee on the cell phone bills, 781 and 131, I believe. Let's take up HB 781, requiring districts to adopt policies establishing cell phone-free education. And call on Representative Litchfield for a motion.
I'd like to make the motion ought to pass, please.
Thank you. Is there a second? Representative Hall, thank you. And Representative Terry, did you have a further motion or discussion?
Yes, I'd like to offer an amendment to HB 781 FN. The amendment is 0733H that was distributed a few minutes ago to all members of the committee.
Thank you, and you're recommending ought to pass on that amendment?
Oh, yes, yes, sir.
Thank you. Is there a second to the motion on the amendment? Representative Hall?
Thank you.
And I'll just mention, the subcommittee was Representatives Terry, Litchfield, and Hall. Representative Terry, further discussion on the amendment?
Was there a second? I didn't hear it.
Yes, Representative
Okay,
Hall did.
Thank you, thank you. Let me just say by way of introduction, I think this is sometimes referred to as a sausage making. I have made sausage in less time than it took to deal with the four sentences in the original 781, but found it to be a very productive collegial discussion, a collaborative effort. And so I am delighted to speak in favor of this amendment. Just to highlight a couple, two or three changes, because I may not get them all. On line 9 of the amendment, the subcommittee added boards of trustees of chartered public schools in addition to school boards of public schools. We also added on line 10, other personal electronic communication devices in schools, because even though we're no longer in school, any of us, we realize that there are other personal electronic communication devices that are in existence and coming online all the time, and we wanted to be sure that those devices were covered as well as this specific item called cell phones. If we go to line 11, the policy shall at a minimum restrict the use of student personal cell phones. The change here in the original language of 781, districts are encouraged to consider such policy shall restrict the use of certain student personal cell phones during class instruction without educator approval. We wanted to be stronger than encourage, because we see this as such a terrible problem that is occurring amongst our youth, and particularly with respect to their time in our schools. And so we wanted to make clear to those who are actually going to implement this law, which would be the school boards and the boards of trustees of chartered public schools, that the policy, we want to be very clear, it shall at a minimum restrict the use of student personal cell phones during class instruction. Therefore, the language is effectively permissive and encouraging them to consider other times during the school day that the local school board or the board of trustees of the chartered public schools might want to include, such as the lunchroom or athletic fields, just as a couple of hypothetical examples. If we move on, we also added the language in line 12 and 13 that we found helpful from the governor's budget proposal, that the policy might have approved exceptions determined by the superintendent or their designee with respect to student medical disability or language proficiency needs. We wanted to make that clear to the school boards and to the boards of trustees of the chartered public schools. Finally, the next to the last sentence, school district policy shall not prohibit students with medical needs such as insulin pumps and glucose sensors or disabilities from using a device to support their learning as identified by the IEP plan developed under Section 504, which is quite broad and inclusive. So we didn't really believe that we needed to go into a lot of detail rather by referencing and including Section 504 of the Rehabilitation Act of 1973, those who would be developing these policies would need to, of course, reference those. And then finally, we went round and around on an effective date. The subcommittee agreed that we would like to have this policy we'd like to have policies in place in our schools beginning with the next school year. Therefore, the act shall take effect July 1st, 2025. We were assured by the school board's association lobbyists that that would be plenty of time for the bodies to develop over the summer their policies and to be able to implement them at the beginning of the school year. Thank you very much, Mr. Chairman.
Thank you. Any further discussion on the amendment? Representative Hall, did you want to comment?
I think
Since you're
that
on the
covers it
subcommittee.
all. Thank you, Mr. Chair.
Yes.
I agree with the need for a policy. But the more I look at the restrictions that are outlined from line 11 down, I'm concerned that we are telling the schools what the policy will be. 9, 10, 11 said they need to create a policy, which is their prerogative, sort of like curriculum. Then we get down from 11 on, we tell them exactly what's in there, which is not our role, in my opinion. Thank you.
Thank you. Further discussion? No further discussion on the amendment? Then, Madam Clerk, could you take a roll call on the amendment?
Seven, eight, one. Okay. Vice Chairman Noble,
Yes.
Representative Terry,
Yes.
Representative Dry, yes. Representative Freeman,
Yes.
Representative Litchfield,
Yes.
Representative McDonald,
Yes.
Representative Morse.
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
No.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Damon,
Yes.
Representative Kluger,
Yes.
Representative Snodgrass, and Chairman Cordelli.
Yes.
16 yeas, 1 nay.
Representative Litchfield, did you have a further motion on this bill?
Yes. Ought to pass as amended, please.
Thank you. Second by Representative Terry. Discussion on the OTPA.
I agree with this and opposed to my fellow committee member, I would even like to see it a little bit stricter because having done lunch duty, I am concerned with watching whole tables of students on their phones and not talking to each other and that just bothered me a lot and I'd like them to have to talk to each other. So if anything, hopefully it could be weaned in a little bit to make it a little bit stricter.
Representative Woodcock?
Preferably with the mouth closed while they're talking. The Representative Cordelli, my concern is not the policy. I think we need a policy. I think the cell phone use, having been in the school and having been an administrator, it's a pain in the neck. That being said, I still don't think it's our right to delegate specifically what is in that and similar to curriculum. This is a local option. Requiring the policy, absolutely. But telling every school system what it has to be without them taking their own prerogative, I think that's not our place. Thank you.
Thank you. Representative Hall?
Mr. Chair, and to respond to that, I think it does leave the school districts with a lot of options. Are you going to let them use it during lunch? You're going to let them use it doesn't say bell to bell. I think what we heard out here was a lot of talk about the bell to bell. And we considered that and thought bell to bell was telling the local folks what to do. This basically says you got to make exceptions to the needs and during classroom instruction. And again, it says personal devices. So if a teacher had devices available to all kids that weren't their personal devices, because you could have a situation where she has a cell phone, I don't have one, now what? You're going to give me a cell phone? So I think it does give them a lot of leeway. Is it, your high school does this, your middle school does this, your elementary school does this? Those are all options available with this language, I believe. Thank you.
Representative Noble?
Thank you, Mr. Chair. I think what we heard out of the hearing is that they don't really want local control. They're looking for the state to hand down the mandate to make it easier for them to put these policies in place so that it's not a fight with parents and kids. That's how I took it anyway.
Representative Murray?
Thank you, Mr. Chair. And just for one point of clarification, I just did want to make sure that there wasn't a potential circumstance where, like classroom instruction, where maybe a scientific calculator would be brought out for instruction or something like that. That is an allowable use of the technology. Am I correct?
Yeah,
Yes.
I don't see any problem in that regard. Yeah.
Right.
Representative Hall?
Yeah, in response to that, I would say it's not a communication device, so that would be
Yes.
fine. Thank you.
Representative Terry?
Yes, just want to respond to a couple of the comments and concerns that have been expressed. A good deal of the 2 hours and 10 minutes that we spent on these sentences in this bill was devoted to considering the delicate balance between the state being prescriptive in terms of what must be done, and on the other side, respecting local control. And so that is, for example, why we adopted the phrase "at a minimum" with respect to the policy. At a minimum, we're saying there needs to be restrictions with respect to use of these devices during classroom instruction. However, local control with respect to other times during the day, we felt quite confident that many of the policies would include the school lunchroom time, but we'll be monitoring that and seeing how that works out. And so I hope that's helpful. Thank you.
Further discussion? Seeing none. Madam Clerk, I think we're ready for a vote on OTPA on House Bill 781.
Vice Chairman Noble,
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
No.
Representative Hall.
Yes.
Representative Baboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass. Yes. And Chairman Cordelli.
Yes.
16 yeas, 1 nay.
Is consent okay for that bill? Great, thank you. And Representative Litchfield, you'll write the report on that? Thank you.
Mr. Chair, is that due by noon or 1 today?
Yeah, the sooner the better. Speaking on behalf of our committee assistant, that is. So the companion bill to that was House Bill 131, which was also related to cell phone use. 131, I'm sorry. Representative Freeman, did you have a motion on House Bill 131?
Yes, I did. Thank you, Mr. Chair. I'd like to move to retain this bill, seeing as we have addressed some of the issues with the last bill.
A second?
Any further discussion? Representative Freeman?
Just briefly, this is almost a mirror bill of the last bill we passed about cell phone usage. So at this time, I think retaining it and either giving it further examination or at some point voting to ITL it would be the prudent thing to do.
Thank you, Representative Terry.
Yes, I'm in support of retaining the bill in case something disastrous, unforeseen and disastrous occurs with respect to 781. I would like to point out that in agreement with Representative Freeman, that 781 and 131 are basically mirror each other. I did not point out before that with respect to 781, that the fiscal piece, the appropriation was removed. 131 does not have the appropriation, but effectively with the bill that we're going to be recommending to the full House and the bill that may be retained if we do vote to do so, there is no fiscal note at this time. Thank you.
Thank you. Any further discussion? Seeing none. Madam Clerk?
Vice Chairman Noble,
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Balboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Chairman Cordelli.
Yes.
17 yeas, 0 nays.
Thank you very much. Consent is okay for that one as well?
Oh, yeah.
Oh, retain, I'm sorry. Yeah. Getting ahead of myself. Next, let's take up House Bill 398, which was not on the list for today, but is an outstanding bill that we did talk about but had not exec yet. Yeah, right. Does anyone have a motion for that? 398? The title on that is Requiring Holocaust and Genocide Studies in Public Schools to Include the Impacts on People with Disabilities. Do you want to?
I'll move ITL.
Thank you very much. Is there a second?
I'll second that.
Representative Freeman? Is there any discussion?
Yes, Representative Selig had checked with the Genocide Commission and they believe that this was already being covered.
Any further discussion?
Just a question, Mr. Chair.
Yes.
Vice Chair, could you just repeat that again, please? Thank you.
Representative Selig had checked with the Genocide Commission, and they believe that this was already being covered. Oh,
Thank-
I'm sorry, Holocaust Commission.
Thank you.
Right. Right. Is there any further discussion? Madam Clerk, when you're ready.
Okay. Motion is ITL. Vice Chairman Noble.
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Balboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Chairman Cordelli.
Yes.
17 yeas, 0 nays.
Any objection to consent?
Nope.
Great, thank you. There were several bills that we wanted to not address today and recess them to next week. They are House Bill 754. There was an amendment passed around this morning, but I think people wanted additional time to look at that amendment, so we will not take that up today. House Bill 121 related to the parent advisory councils. I still think that we have some work to do in terms of the formation of those councils and who is going to do that. So we will hold on that. And the prime sponsor on House Bill 360 had requested some additional time to look at that bill as well. None of those are early bills, so we will address them at a future session. So let's move, excuse me, I don't know if I mentioned House Bill 699. I would include, to hold off on that also because evidently due to my error, we don't have copies of those. And I passed out duplicates of 754 instead. So, I'll try and get copies for next week of 699 amendment. That brings us to House Bill 361, prohibiting mandatory mask policies. And if she's ready, I look to Representative Noble for a motion on that.
Thank you, Mr. Chair. I move ought to pass.
Thank you. Is there a second? Representative Morse. Representative Noble, would you like to comment?
Oh, just a few comments, actually. This bill doesn't prevent masking in schools. Anyone is free to do so. They just can't be mandated for everyone. It was mentioned in the hearing that it's good that there's a carve-out for IEPs and 504s, but the thing is, if this bill doesn't pass, there is no carve-out for students with IEPs and 504s if there is a school mandate. There wasn't last time, at least. We know enough now about the impact on children to be able to do a proper risk-benefit analysis for any potential public health event in the future, just like many of us parents did from the beginning. But there are some that still don't know that, and that is one of the dangers in leaving this up to local control. I've read the online testimony and emails opposing this bill, and there's really no acknowledgement about how masking affected children and their education. If we were to have another public health emergency, we can't leave this to school boards to deal with. We can't have them in the middle, getting yelled at by two different sides. We also can't have one district that masks and another that doesn't. Local control just doesn't work in this type of situation. Also in the online testimony, there was a letter from the Department of Health and Human Services, the Division of Public Health Services. And I'll just read that to you real quick. Department of Health and Human Services, Division of Public Health Services is providing the following information to the Education Committee in consideration of HB 361 relative to prohibiting mandatory mask policies in schools. Face masks remain an effective tool for protecting a person and preventing the spread of many infectious respiratory diseases. Division of Public Health Services continues to recommend that decisions on face mask use be based on individual choice and informed by a person's own assessment and acceptance of risk from currently circulating infectious diseases rather than from universal requirements. For example, individuals who are severely immunocompromised or who desire additional protection for themselves or another household member can choose to wear a face mask for their protection when in indoor public locations. This recommended approach to face masks is also consistent with the Centers for Disease Control and Prevention updated guidance on mask and respiratory virus prevention. Thank you for the opportunity to provide this information. The department strives to provide public health protection while appropriately balancing individual choice. And I thank Director Watt for that letter. And that's all I have. I actually have the letter. I forgot about that. God, I made copies for you all. And that's all I have, Mr. Chair.
Thank you. Representative Morse, did you have anything to add? No. Any further comment? Representative Hall.
Thank you, Mr. Chair. I'll be voting no on this ITL. I guess no. School boards, again, it is local control. No one can predict what's going to happen in the future. And I think school districts, school boards can deal with the IEPs, and I have complete faith that school boards would take that into consideration. So I'm voting ITL on this.
Thank you. Further, Representative Damon, welcome to Education and Policy again.
Thank you, Mr. Chair. Representative Dwight and I are trying to cover all bases. I'm opposed to this bill, and I speak as a healthcare professional, now retired. I would also note in the online testimony, there is a thorough letter from the New Hampshire Nurses Association opposing the bill. It is critically important that we all make our decisions based in fact. And the fact is, situations could be different in different districts, and us on the state level dictating what should or should not happen in public health and safety doesn't make sense. I differ respectfully with Representative Noble in that we should, in fact, benefit from each district making the decisions that are relevant. You could have an outbreak of an infectious disease in Manchester that isn't affecting the North Country, or vice versa. The decisions should be made locally. Thank you.
Thank you. Representative Murray.
Thank you, Mr. Chair. I too will be voting no on the ITL, and I think in addition to Representative Damon's point, one of the things that we saw were a myriad of different data dashboards during the pandemic. They came up that showed various levels of infection rates, and I think that that was a very data-driven opportunity to take a look at where information was coming from based on testing results that were coming back throughout the state. And that is something that I think when we talk about listening to science, that was one part of the local control aspect that was very data and science driven.
Thank you. Representative Woodcock.
Thank you. Surprisingly to note, I will also be voting no on this. But that being said, I think we have learned from the situation that the vice chair talks about, ways to move forward in the future. And by handcuffing local schools and not allowing to use what they've learned, it makes no sense to me. Because the board, the health community has learned, the towns have learned, school boards have learned. It's time to let them do their job with the new information. Thank you.
Thank you. Any further discussion? Seeing none? Seeing none? Madam Clerk. This is ought to pass on House Bill 361, prohibiting mandatory mask policies in schools.
Vice Chairman Noble,
Yes.
Representative Terry.
Yes.
Representative Dry, yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Absolutely yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No on ought to pass.
Representative Woodcock.
Absolutely no.
Representative Hall.
No.
Representative Balboni.
No.
Representative Damon.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
Chairman Cordelli.
Yes.
9 yeas, 8 nays.
Thank you very much. Let me see what else we have. House Bill 286, I think we can bring up next, which is a study committee to investigate if one school superintendent per county is feasible. Representative Freeman, did you have a motion on House Bill 286?
Yes, thank you, Mr. Chairman. I vote to ITL this bill in expedient to legislate.
Thank you. Is there a second? Representative McDonald, thank you. Representative Freeman, did you want to discuss your motion?
Very briefly, thank you, Mr. Chair. While this in theory is a good idea, I do believe that we already have an RSA on the books that allows for districts to consolidate their SAUs and hence would address some of this problem with the study committee on looking into whether we should have one school superintendent or not. That and every county is different, different sizes. I cannot in good conscience say that Hillsborough County would be a good example of having one superintendent. So to that end, I will ask people to vote in expedient to legislate.
Thank you. Representative McDonald, did you have anything to add?
Yes, I would briefly. I agree with Representative Freeman entirely. I'll also add that we have several study committees in law already. It seems needless to me to put another study committee into law when we could probably all answer this question today. It's probably not feasible. You mentioned Hillsborough County. I would say where I am in Rockingham County, also not feasible. That's not to say I'm opposed to SAU consolidation, but I don't think this bill is the answer to do that. Thank you.
Thank you. Anything further? I'll just add, we have a couple of SAU-related consolidation bills still to bring up. I consider this in the same vein. We want to take a look at those other two bills upcoming, but they're not early bills. So, please take a look at those, and I'll get those scheduled for discussion in the remaining 2 weeks that we have. If no further discussion, Madam Clerk, we're ready on House Bill 286, I believe.
Motion is ITL. Vice Chairman Noble.
Yes.
Representative Terry.
Yes.
Representative Dry. Yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
Yes.
Representative Murray.
Yes.
Representative Woodcock.
Yes.
Representative Hall.
Yes.
Representative Balboni.
Yes.
Representative Damon.
Yes.
Representative Kluger.
Yes.
Representative Snodgrass.
Yes.
Chairman Cordelli.
Yes.
17 yeas, 0 nays.
Any objections to consent? Seeing none, thank you very much.
I'll open the executive session on HB 709, allowing parents or guardians to admit their children into any school district where they pay any property or school district taxes. And I look to Representative Cordelli for a motion.
Thank you. I would move that we retain House Bill 709.
Is there a second? Representative Terry? Representative Cordelli, any discussion?
Yes, thank you. I think that there were questions raised about this bill and the property being involved as possibly second homes, etc. We do have some similar bills related to public school districts coming up. I did talk to the prime sponsor of the bill about retaining this and possibly looking at resolving some of the problems in the future if needed. Otherwise, we have other options for it when it comes to the time for retained bills in the fall and a vote in January.
Any other discussion? Representative Cornell.
Thank you, Madam Chair. I am glad it's going to be retained because I don't agree with it, but I will be voting against the retain because I would rather vote ITL on this. So, but I'm happy that it would be retained.
Any other discussion? Seeing none, Madam Clerk, the motion is to retain.
Vice Chairman Noble.
Yes.
Representative Terry.
Yes.
Representative Dry. Yes. Representative Freeman.
Yes.
Representative Litchfield.
Yes.
Representative McDonald.
Yes.
Representative Morse.
Yes.
Representative Nato.
Yes.
Representative Cornell.
No.
Representative Murray.
No.
Representative Woodcock.
No.
Representative Hall.
No.
Representative Balboni.
No.
Representative Damon.
No.
Representative Kluger.
No.
Representative Snodgrass.
No.
And Chairman Cordelli.
Yes.
9 yeas, 8 nays.
Thank you very much. I believe that takes care, Representative Cornell, I think that takes care of all the bills we had discussed to take care of this morning. But I did want to, it gives me some time to take care of reports that I owe. And a couple of early bills that we especially need to take care of. But there are bills from this morning. Since we have a little bit of time, maybe if Representative Noble, could you go over the reports that would be required? And maybe if someone has time to write a report this morning, so we could get them into the calendar for next week, it would be very helpful.
Want me to read it out right
Yes, if you could.
Representative Drive for HB 763, Representative Litchfield for HB 781, Representative Noble for 398, Representative Noble for 361. How did I get all these? And Representative Freeman for 286. Representative Hall for 361. Minority report.
Question? With respect to 781, Mr. Chair, since the fiscal section was dropped, is this now 781 clean or 781 FN with no FN?
It continues
Yeah.
that way,
It continues even though it doesn't have a fiscal note.
right?
Thank you. I'll know that for the next Jeopardy session.
Right. So if those people could work on those reports, we'll see if we can get them processed by 1 o'clock and get them onto the calendar for next week and save us some work in the future, which is a good thing.
Yeah.
Great. Thank you very much, and we'll.
Mr. Chairman,
Yes.
just to be perfectly clear, the calendar this afternoon indicates executive session on pending legislation may be held throughout the day. It appears as though there will be no pending legislation acted upon, but I just want to be clear. Do you intend to have any executive sessions this afternoon?
I do not expect that.
Okay, thank you.
I'm sorry, I was talking, I missed what
He just asked if we were going to exec any more bills this afternoon, and I don't expect that we will be. So, so if you can get,
Mr. Chair, I would like to thank you for being like that in this committee and not doing surprise execs. I really appreciate that. Thank you.
you can thank me after crossover as well, maybe. Thank you, and we'll reconvene at 1 o'clock.
Oh, yes. Good work.
Do I have to do any? No.
You could be nice and do some assistance. You could be nice and do some assistance.
I mean,
I'm not that nice.
last year.
for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We'll open the public hearing on non-germane amendment to HB 50 relative to intentional or knowing violation of the prohibition on teaching discrimination. And I welcome Representative Cordelli, the prime sponsor.
Thank you very much, Madam Chairman and fellow members of Education Policy. For the record, Glenn Cordelli, representing Tufton Borough, Wolfboro, and Ossipee in the beautiful Lakes region. And this is a non-germane amendment to HB 50. It's the same general topic, but it slightly revises the intent of the original legislation, in that the original intent was repealing much of what was in statute, both in 193 and in the human rights section of statute, related to the topic of concepts that some call divisive concepts, but they were concepts related to, I think, equal treatment of everybody. So what my amendment does instead is address some of the rulings by New Hampshire judge in a case, a lawsuit that was filed against these concepts in statute. There was a lengthy brief that I do have copies of if anyone's interested, but I'll just touch on one aspect of the judge's ruling. And I believe there's someone here who can further explain where the case currently lies. But one of the areas that was the basis of the lawsuit was vagueness related to violations of the Educator Code of Conduct and what might qualify in that regard. So my bill intends to address that vagueness that the judge felt was inherent in the law. And it's not a lengthy amendment, as you can see, but Roman 3 and 4 addresses violations by adding the words intentional or knowing. So to be considered in a violation, someone has to knowingly or intentionally act in this manner. And the court ruled that this was vague in the original law, and it's the vagueness was categorized. It does not include what was termed a scienter clause, and I can read from the judge's ruling, which basically quotes Black's Law Dictionary. Scienter is the degree of knowledge that makes a person legally responsible for the consequences of her or his act or omission. So this is meant to address that and make them responsible for the consequences of their actions by indicating that the action has to be intentional or knowing. And the judge in that New Hampshire case went on to say, the value of a scienter requirement is that it limits a law's scope to those who knowingly engage in a particular course of conduct. So the entire purpose of this amendment is to address that concept of vagueness in the current law and make sure that we know that the intent of the person is intentional or knowing, and that would be a violation. I thank you very much.
Thank you. Any questions? Seeing none, thank you.
Thank you.
Representative Murray.
Thank you, Madam Vice Chair. For the record, my name is Megan Murray. I represent Hillsborough District 37, that is Amherst and Milford. I am a co-sponsor on the underlying bill of House Bill 50, and I'm here to testify in opposition to the non-germane amendment of 2025059H. And I'll just start off by saying that the premise of the law and the underlying bill addresses has already been deemed in a federal court to be unconstitutional. It stands to reason that unless the law is repealed by House Bill 50, that we potentially further encumber ourselves to litigation around the constitutionality of the bill and the topic as amended with Amendment 2025059H. 05995H. The First Amendment protects free speech, and I'm not sure how this amendment would comport with both the First and 14th Amendments, given that sometimes honest yet uncomfortable representations of historical truths could be construed as, quote, knowing violations, when in fact they're just facts. I urge the committee to vote no on the non-germane amendment so that House Bill 50 can move forward unattached, repealing an unconstitutional law. Thank you.
Thank you. Any questions? Representative Dry.
Thank you, and thank you for taking my question. Can you explain to me what is specifically unconstitutional?
So I think there's a potential for a conversation around the constitutionality of there being, quote, knowing or intentional representations of fact. I'm not quite sure how you would determine that when an educator is teaching in the classroom. So I feel like that could become a very slippery slope where it could be overly litigious, and people could be, and districts could be in a situation where they find themselves consistently in litigation.
Follow up?
Thank you. What in the Constitution does that violate?
So when I was talking about the First Amendment, free speech, around facts, teaching those in the classroom.
Any other questions? Representative Cornell.
So, thank you, Madam Chair. So it sounds like this was put in to clear up the vagueness, but it sounds like an intentional or knowing violation could also be considered vague because we don't know how do you determine that it was intentional or knowing? So that could be that could be vague also.
Yes, thank you for the question. I believe so. And I think that that it further stands to put teachers and educators in a position where they're constantly having to, yet again, defend what is a factual or historical truth.
Any other questions? Representative Terry.
Yes, with respect to the language that is in view most immediately and upon which you have opined, an intentional or knowing violation, would you object to having the court rule as to whether that is satisfies its concern for clarity as opposed to your opinion being a sufficient basis not to go forward with this? Do you trust the courts to be able to determine that?
I'm not sure I'm understanding your question.
You said earlier in your opening statement that if we adopted this amendment, that it would open us up to unnecessary extended litigation. Did you not? Or
I said that was a potentiality, yes.
do you have a problem with that? Litigation over clarity of language, meeting the law.
I'm not sure what I'm understanding. That is just a fact of the judicial process. What I am saying is that by default, it could potentially open the situation up to further litigation. That's all I'm saying.
Recognizing that we're not in the United States House of Representatives, I should probably defer now, but I'd love to go on for another 3 minutes. Thanks.
Thank you. Any other questions? Representative Cornell.
So, thank you, Madam Chair. So if this did go into litigation, who would be responsible for the cost of the litigation?
It's a great question. I'm not entirely sure, but it would stand to reason that you would think that if somebody was being implicated in knowing it could either be the educator themselves or the district. It seems like that's how I was
So
looking
the
at
taxpayers of the district could be liable for the cost of the litigation.
potentially.
Thank you.
Any other questions? Seeing none, thank you. Representative Horgan?
Thank you very much. I'm resident Timothy Horgan from Stratford County's District 10, the town of Durham, and I support the underlying bill. I would have been happy to be a co-sponsor of it, but not one of the names on the masthead. But I think that's an excellent bill, 19340. It's a very bad law. I mean, aside from the fact it violates both the federal and state constitution, it's also bad policy. We need to teach children about these concepts. What sort of has been, what's sort of been lumped, at least by some, under the acronym DEI, and what I should say DEI stands for diversity, equity, and inclusion. And those are three things I don't think any, well, maybe diversity, but like we're a diverse, New Hampshire's a diverse state, the United States is a diverse society. There's no way around that. And I'm not sure who could be against equity or against inclusion, if you put it that way. But if we call it DEI, that's different. I don't necessarily, I'm a little bit uncertain about saying what's in the Constitution that's still being observed and what isn't. But we have a state constitution which also guarantees the right to freedom of speech and freedom of conscience. So that's certainly still in place. I mean, I trust the courts more than some other institutions. I would, but also I'd say there's a process issue here, which is this bill hijacks, the non-germane amendment. It completely replaces a bill, and it has essentially the opposite aim of what the original bill was. At least, I mean, it does add this language about intentional or knowing. I really don't know if that makes the bill any better. It doesn't address other problems. Just every subparagraph in 19340 has problems. We're talking about where the litigation is. I mean, because anytime you guarantee people's rights, if the rights are violated, they can litigate. And I looked at it, and so you can either bring a lawsuit in the Superior Court or with the Commission on Human Rights. Commission on Human Rights has a lot of structural problems, so we probably shouldn't be adding any more work to the Commission on Human Rights. And I'm not even aware that they've actually taken on any cases inspired by 19340. But certainly this bill, the amendment, either doesn't improve 19340 in any way, or it may even actually make it even vaguer, and it certainly doesn't attack any of the problems with it. So in that regard, it has the exact opposite of intent of what the sponsors intended, which was just to strike this bad statute from the law books. Well, I guess it did replace it with sort of a general statement of ideals. So from that regard, I think there's huge process problems with the amendment, even though our rules do allow us to do it. And it's, I think, somewhat disrespectful to the sponsors to do it, especially since this could have been attached to some other bills. And I've had bills hijacked in the past to do the opposite of what I had in mind. And, it's part of the game that we play here. It's allowable, but it's really not, it's not a good tactic. And so it's really, in my opinion, that's probably not the right way to go about achieving the same. So I think it was a little bit unfair to do that to the sponsors, especially since there's many other bills this non-germane amendment could have been attached to. So I would just urge you to reject I hope the committee will reject the non-germane amendment, but I hope they'll pass the underlying bill. So that's all I have to say about it. So pass the underlying bill, reject the amendment. And so I'd be happy to take any questions if anyone has any, but.
Thank you. Any questions?
Looks like.
Representative Morse.
Yeah.
Thank you for taking my question here. In the current statute, RSA 19340, section 1A, it states teachers cannot teach one student of whatever race, gender, sexual orientation, or disabilities that they are superior to another. So if we're repealing 19340 with HB 50, then wouldn't that unbind teachers' hands, allowing them to teach students that they are minorities and further propaganda on our students?
I not sure how to answer that. I mean, that's something that they should not have been doing. That was something that would have been bad. I don't know of any cases where teachers are actually doing that. So I probably think if I decline to answer your question, I can point out you'll have an executive session, probably some work sessions. So maybe you can discuss that with your fellow committee members, and or if you can find some instances of teachers doing that, maybe you can share that information with the committee. But that was something that was already not allowed before. RSA 19340 was rather hastily passed in the law as part of the budget trailer bill 4 years ago. So that's about all the answer I have for that. So thanks.
Any other questions? Seeing none, thank you. Shannon McGinley.
Thank you, Chairwoman Noble and the members of the committee. I am Shannon McGinley. I'm the Executive Director of Cornerstone Action here in New Hampshire. I'm testifying on Amendment 0595H to HB 50. Cornerstone is New Hampshire's only full-time Christian advocacy organization representing over 100 churches around the state. After the passage of the CRT law, we became the primary organization in the state helping parents report violations of the law. Unfortunately, although we helped report at least 67 educators who were credibly violating the law, the Department of Education did not investigate any of those teachers. Although Amendment 0595 does not hurt our law, and we will not oppose the amendment, neither should this committee think that it will get the law up and running again. In the district judge's ruling enjoining our law, the judge's main argument, taking up most of his opinion, was that the substance of our law was ambiguous. In particular, the judge said it was not clear whether the law prohibited teachers from promoting affirmative action. While we think that the judge's decision was politically motivated, he did leave us a clear path to get the law up and running again by directly addressing this supposed ambiguity. It is true that the judge also said that the law needed a clear mental state requirement, and this amendment addresses that. However, that was only one very minor part of the judge's opinion. There is no legal argument that this small change will be enough to restore the law. We understand that the Department of Justice is asking legislators not to significantly amend the current law, but it is no secret that our DOJ is full of attorneys who politically opposed passing this law in the first place. And it was the DOJ that consistently pressured the Department of Education not to even investigate any violations of the law, rendering the law ineffective before it was even enjoined. If the committee wants to restore the CRT law, as we do, I hope it will seek a second opinion outside of our state agencies. While I want to offer the services of our own staff litigator in crafting an amendment, so far our experience has been that every attorney outside the DOJ agrees that simply changing the mental state element in this law will not address Judge Barbadoro's opinion. Thank you, and although I'm not an attorney, I will do my best to answer questions. I do just want quickly, Chairman, to point out when somebody was talking about previously this question of intentionally or knowing, where their mental state was. We do that all the time in law. It's not a unique thing. Thank you, Chairman.
Thank you. Any questions? Representative Woodcock.
Thank you, Madam Chair. Good afternoon.
Good afternoon.
I just have a question. You
Yes.
said in your testimony, I think I get this right,
Okay.
that the DOJ pressured the Department of Education not to prosecute this law.
That's correct.
Can you give me an example of that?
In multiple conversations that we've had with people in the DOJ that was the situation. It's not, there's nothing public that I can provide you now.
So there's nothing, Madam Chair?
Yes, follow up.
Thank you. So there's nothing that you actually have to substantiate that the DOJ pressured the Department of Education not to follow through in their obligation.
I'll have my attorney follow up with you and he can share that information.
Thank you. Thank you, Madam Chair.
Representative Dry.
Thank you. Thank you for taking my question. I just want to get this right. It says you oppose the bill, but the amendment is,
We just want to be clear that it's not going to resolve the concern that we have with the Department of Education not being able to enforce it.
okay, follow. So when it says opposes the bill, I want to get this right, correct.
Correct.
The
I
original
oppose
bill.
Cornerstone opposes the underlying bill, and we would support very much a non-germane amendment, but we believe that that this language needs to be tweaked in order to address the problem.
Thank you for clearing that up.
Thank you very much.
Any other questions? Oh, Representative Cornell, sorry.
No,
Okay.
Thank you, Marcia. That was my question. I couldn't tell from your testimony whether you opposed or supported
The underlying bill?
non-germane amendment.
Oh, okay. Yeah, what I said in that was that we don't oppose the amendment as it is, but we want to be clear that it's not going to truly address the issue that it's trying to address. But it's not going to hurt it, like I said in my testimony either. Thank you.
Representative Litchfield.
Thank you, Madam Chair, and thank you for taking my question. Would you be willing to forward suggestions to the committee?
Yes, definitely.
Thank you.
Any other questions? Seeing none, thank you.
Thank you. I have copies of my testimony. I'll pass them out, and I'm really sorry about the blue lines on the side. Thank you, printer cartridge.
Sam Garland.
Thank you, Madam Chair, and thank you to the committee. My name is Sam Garland. I'm a Senior Assistant Attorney General at the Department of Justice. I oversee the Civil Litigation Unit and have been involved in the litigation around the underlying law. I'm neither here in support or opposed to the non-germane amendment or the underlying bill, but I'm here to try to provide technical guidance to the committee and answer any questions you may have. And I think one thing that may be helpful that I intended to talk about was just kind of the course of the litigation to date and where the case currently stands. So I was planning to start there. And so as Representative Cordelli pointed out, there was a challenge to the underlying law that was passed back in 2021 in federal district court. We litigated across several years, and there were First Amendment challenges and 14th Amendment vagueness challenges, a due process clause, a challenge to the law that were litigated both kind of at a motion to dismiss stage and then after discovery and a motion for summary judgment. The district judge ruled that at least with respect to curricular speech, so the speech that teachers make within the classroom, that wasn't protected by the First Amendment. He left open whether the bill reached non-curricular speech that would be protected by the First Amendment. But then he did ultimately rule that the law was unconstitutionally vague in violation of the 14th Amendment. So there's a long history of case law that if a law is too indeterminate for people to understand what it precludes or what it prohibits or would allow for arbitrary enforcement, it can violate the 14th Amendment. So that was the basis of his ruling. He identified really three different things that contributed to it. I mean, I don't want to say they're unrelated, but three different factors that he believed were what contributed to the vagueness. One was, as Representative Murray pointed out, and this was a big focus of the opinion, really the conduct that was being prohibited. He expressed concerns in his opinion about those four categories and whether they were sufficiently clear to put a person on notice as to what was being prohibited. But then he also said that there were two other factors of the law that required that it be more precise than ordinary legislation, that it be subject to what he called a more exacting vagueness standard. And those two things were the fact that there was a penalty. The Educator Code of Conduct violation can have licensure ramifications. And so there's case law that he noted that supports the idea that if there's a penalty associated with a law, it needs to be more precise. And then also that there was no mens rea or scienter requirement. And that's what this amendment, as I understand, it's designed to address. That when a law doesn't have a specific mental state that's required to violate it, it is more susceptible to arbitrary enforcement. It's more susceptible to not putting a person on notice as to how they violate the law. So this particular amendment addresses that concern that the judge said contributed to him applying a more heightened vagueness standard by putting in knowing and intentional, which are common mens rea states, common scienter states that exist in criminal law and in civil laws. So as I understand it, this would address one of the concerns. It isn't clear whether that would ultimately change the outcome of the litigation. That's it's impossible, and I know this is a lawyerly response, but I mean it genuinely. I don't know if this bill passed whether it would ultimately change the outcome of the litigation, but it does directly address one of the big concerns that the judge noted in the law. In terms of the process, the case is currently on appeal at the U.S. Court of Appeals for the First Circuit in Boston, which is our appellate court for northeastern states, the intermediate appellate court. It's mostly briefed, and there's an oral argument scheduled in Boston for April 8th that we'll be arguing at that point. I don't know how long it will take after that for the First Circuit to rule. It can be a matter of weeks or months. It can be the better part of a year. It's an appellate court, and we don't have a huge amount of control over that. At which point, however the court rules, we'll have more guidance from a court on whether, this panel of 3 judges as opposed to a single judge believes that the law is unconstitutional. If the court believes that it is, then, our office will have to assess options, and the next step is the U.S. Supreme Court from there. So all of that's to say the litigation is ongoing. We have defended the underlying bill, and again, I'm not here to oppose anything as a matter of policy, but we've defended it, and we defended it vigorously in district court. We are briefing and defending it in the First Circuit, and this amendment would address one of the concerns that the federal judge identified in the underlying law. And I welcome any questions that folks have.
Thank you. So the state is prepared to fight this in the Supreme Court if it doesn't prevail in the First Circuit.
I can't commit to that here. I mean, that's a question that's outside of my authority to answer. It ultimately, any sort of appeal has to go through our Solicitor General and ultimately through the Attorney General. And so that's not something that's sitting as as litigation chief I can answer, but it's certainly something anytime we get an adverse ruling in court, our office assesses, whether that's in a civil case like I'm involved in, a criminal case as well. So I can't commit one way or the other to that. I know it's a frustrating answer, but that would be the next step from the First Circuit.
Okay. Representative Terry.
Yes, thank you. Sir, the previous witness indicated that there were 67 cases or complaints that were filed by individuals with respect to the claim of violation of the law. Are you in a position to be able to, given your position, to be able to tell us whether in fact you can confirm that any number between 1 and 67 cases, which the previous witness has indicated that she will supply the committee details with, any number between 1 and 67, given that you have said that you will be vigorously supporting the law in court, that seems to run counter to the claim that between 1 and 67 complaints that were made, or up to 67 complaints that were made, were not acted upon by the Department of Justice with respect to its relationship to the Department of Education. Is that so to your knowledge, or does this come as a shock to you today?
I think I understand your question. There are a couple different parts to it. So if you'll indulge me, I'll try to answer it.
And if that in fact has any basis in truth, what would be the reason to not act upon the complaints that were filed in a positive manner? So
the answer to the first part of your question, the Department of Justice doesn't play a specific role under the statute in enforcing the law. The underlying statute has 2 enforcement mechanisms. One is an educator board of conduct proceeding before the Board of Education that the Department of Education brings, and the other is an action either in Superior Court or the Human Rights Commission for violation of the anti-discrimination laws. And our office, and this is in our briefing, took the position that and this happens quite commonly when there are 2 different state agencies that have enforcement authority, that the process needed to go through the Human Rights Commission first, and ultimately to find a violation of the law before the a Board of Education proceeding could start. And that's just a structure of the law position that we took, and it's one that I think is a fair reading of the underlying law, and we represented that in court. In terms of the numbers, I really don't know sitting here today. I'm not aware of any specific number of matters that was filed in the board or in the Human Rights Commission, though I know there were some, and I don't know how many that was. And because the Human Rights Commission process was kind of the first step in the process, I don't believe that there were any formal Board of Education matters filed, but that was because of the guidance that we provided in terms of kind of how the process went to the HRC or to Superior Court first, and then ultimately went to the Board of Education. I'm happy to provide follow-up information. Sitting here today, I can't confirm or deny 67 or whatever the number would be, but hopefully that's helpful in explaining the process.
So just to be clear, to the best of your knowledge, you have not been involved in any of these alleged cases or complaints that have been brought by the previous witness indicated 67 individuals. That because of the process that you've outlined and how these sorts of things are addressed and handled, you have not even had the opportunity or been given the opportunity or been requested to be involved at this point.
So the Department of Justice is not involved in formally enforcing the law. So the Department of Justice doesn't bring a case in the Board of Education, I guess is the more direct answer to that question. In terms of what we have counseled state agencies in terms of the process, I mean, we've provided in our written filings kind of the two-step process that I just explained. I wouldn't be comfortable going into anything else that we've advised agencies, just as our role as agency counsel.
Representative Hall.
Madam Chair, kind of a follow-up to those questions. We heard from the previous speaker that the DOJ pressured the DOE. I mean, those are that you pressured the Department of Ed. Can you speak to that?
I don't want to put words in. I believe that the answer to that question is how I just answered the last question, which is we did take the position of how the process plays out, that it's HRC before it goes to the Board of Education, because, and there are prudential reasons for that. You don't want two different boards looking at the same underlying conduct, simultaneously diverting resources and coming potentially to opposite conclusions. So the guidance that we provided was that it went to the HRC first and then it ultimately went to the Board of Education. I can't speak to any specific conversations, and I don't know that I would characterize that as pressure, but I can tell you that is the formal position we took about how the law was to be enforced.
Thank you.
Any other questions? Representative Morse.
Thank you for taking my question. I just had one clarification piece. You mentioned earlier about the First Amendment being exempt from classrooms. Could you just kind of clarify on that a little bit?
Sure, I can speak to my understanding of how the judge ruled on that. So there was a question about the First Amendment challenge was along the lines of teachers being forced to speak in particular ways or not forced to speak in particular ways that would violate their own First Amendment rights. And there's case law, and it's not unique to New Hampshire, that when teachers are making pedagogical speech or curricular speech, classroom speech, that's not protected by the First Amendment. There's U.S. Supreme Court case law that kind of touches on the overarching issue of official speech versus private speech. And then there's kind of the downflow of that to the classroom. And so at the earlier stage of the case in the motion to dismiss, the district judge ruled that, and with respect to this law, that was true as well, that to the extent it was affecting curricular speech, classroom speech, it didn't implicate the First Amendment. That didn't resolve a question that ultimately wasn't resolved, because the district judge took the view it didn't need to be, which is to the extent this law reaches extracurricular speech, whether that is subject to some protection and whether it would ultimately create a First Amendment problem there. The plaintiffs made that argument. We addressed it in the briefing, but because the judge viewed the law as unconstitutionally vague, it ultimately kind of rendered moot that question. So, but to specifically answer your question, it was around the First Amendment protections afforded to curricular speech.
Any other questions? Representative Cornell.
Thank you. You said that this amendment would address the third point, specific mental state of, so that would say any person claiming, so that any person could be my neighbor's uncle claiming to be aggrieved by an intentional or knowing violation. How do you know something is intentional or knowing? Somebody could do something and then when they asked about that, that's not how I meant it to come across. So how do you determine that it was intentional or knowing?
I think you would be better served having a criminal attorney here, because that's the venue where that more often comes up. But ultimately, it is a question of whether through direct evidence or circumstantial evidence you can prove kind of the legal standards for intent or the legal standard for knowing. There has been a fair amount of litigation around whether those standards themselves are vague, and that came up in the context of this. And what our U.S. Supreme Court has said is that it doesn't necessarily resolve the question in any particular case whether there is a constitutional issue with respect to an application of a statute. But when you have those kind of well-worn concepts in a law, generally speaking, it can help protect it against a facial challenge, a challenge that the law is completely unconstitutional in all of its applications, which is how the judge ruled in this case. I'm guessing that's not a satisfying answer, but the short answer is knowing and intentional conduct, or knowing or intentional conduct, is commonly something that a prosecuting entity has to prove. It can be hard to prove. You need to prove it through direct or circumstantial evidence that would persuade by the standard of proof that applies that it's overcome. But courts have recognized that because those concepts are kind of inherent in our judicial system, they in and of themselves don't create a vagueness problem.
Representative Damon.
Thank you, Madam Chair. Thank you for helping us with this. Is it correct or not that part of the role of the Department of Justice and perhaps yourself is to advise other agencies, including the Department of Ed, when it is appropriate to proceed with a judicial filing?
In terms of defending, just to clarify, in terms of defending a statute, like us going into court and defending it, or in terms of when to bring an action under a statute? Because my role is has been to defend our unit, to defend a statute when it is challenged on constitutional grounds. We aren't the entity that would prosecute an action under the statute if you were going to seek an educator code of conduct violation or something of that kind.
May I continue? So yes, in light of what you just informed, could you just walk us through a little bit more how that would work so that whether it's this statute or I'm just trying to pull back and get sort of a broader picture, generally how DOJ would interact with other agencies by way of trying to further clarify what may or may not have been pressure from DOJ to DOE?
Understood. Yeah. The thing I can't speak to, and this was an answer in response to your question to Representative Terry, is any sort of attorney-client communications, because the agencies and at times the legislature and at times the governor's office are clients when our legal advice can come up, and so I can't speak to that. But what I can say, generally speaking, is that agencies come to our office all the time asking for guidance on legal questions. And we have a client counseling unit. It's kind of the counterpart unit to the one I oversee within the Civil Bureau that provides legal advice to agencies. And that's true of every agency in the state. In the governor's office, and there have been times when the judicial branch and the legislature require legal guidance to or legal representation, and the Civil Bureau does that. So it can be across the state government.
Any other questions? Seeing none, thank you for coming in.
Thank you very much.
Diana Fenton.
Good afternoon. For the record, my name is Diana Fenton. I'm an attorney with the Department of Education. I'm here to answer questions, and I don't really have a whole lot to offer, but we were being mentioned quite a bit, so I certainly wanted to make myself available here. Our understanding, the department's understanding of the law, and if you look at RSA 193:40. It starts on page 561 and it goes on to page 562. But I'll focus your attention on page 562, Roman numeral 3. And without violating any attorney-client privilege with the Department of Justice, which I know right now they're looking behind me going, oh, please don't. And I promise, Sam, I won't. But if you look on the DOJ website, they issued we call them technical advisories. What do you call them?
It was either an attorney general opinion or frequently asked questions.
There you go. A really important document. Let's call it that, shall we? It's right on their website. And they issued guidance on the interpretation of this law. That's what the Department of Education followed. And I would encourage the members of this committee to look on the DOJ website. Look at the guidance they issued. That's not attorney-client privilege. And if it is, well, Sam, it's been violated. It's public. So it's right there on the website. And I know there's been a lot of talk and chatter about what the department did or shouldn't have done or 67 cases. But the interpretation of RSA 193:40 was already done years ago by the Attorney General's office. And it's written very clearly in Roman numeral 3. It says, any person claiming to be aggrieved by a violation of this section may initiate a civil action against a school or school district in Superior Court, That's not the Department of Education. For legal or equitable relief, or with the New Hampshire Commission for Human Rights. Those two entities were the area where these cases were investigated and litigated. And in Roman numeral 4, if there was a finding, a violation of the section, if there was a finding that there had been a violation, then, and only then, did the jurisdiction transfer, if you will, to the Department of Education for a penalty to be imposed. Now, you know I'm no fool, so I'm going to turn around and check with Sam and make sure I got that right. Ready? Here we go. Sam, we good? Oh, I love when he says that. Makes my day. That was the role the Department of Education played under this statute. That's how the law is clearly written. And that interpretation was supported and enforced by the DOJ's, I'll call it advisory opinion, but let's just say really important paper that's on their website. And I would encourage you to take a look at it. That's what the Department of Education followed. Oh, look at that. You're already ahead of the game. I should have known. That's why she's in charge. That's the role the department played in this. I'm not aware of the 67 cases. I don't know where that number comes from. I don't dispute it. I don't mistrust it. I'm just not in a position to say, yes, that's an accurate number or it's not. Because again, I want to highlight the law is clear as written. It follows the interpretation by the Department of Justice, and the Department of Education's role in this was limited to simply the penalty if there was a finding from any of those other entities, the Superior Court or the Human Rights Commission. That being said, I'm happy to take any questions and I appreciate your time. I know it's been a long day already.
Any questions? Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. Okay, again, for clarification, if I had an issue and I thought that one of these violations had happened in my school, where would I report it?
You would report it, you would initiate a civil action in Superior Court, or you would file with the Human Rights Commission. And my understanding was that the Department of Education was receiving a lot of these complaints. As that's understandable. As a member of the general public, I would put the two together. We would re-refer them to the Human Rights Commission. And I believe there was a link on our website. You remember this? Sam's going to leave. He's like, I'm going to sneak out the back door. There was a link on our website that went directly to the Human Rights Commission.
Clarification?
Yes.
So just again, a clarification. If I was reporting, there was a link that was on the DOE site.
Yes.
That nobody at the DOE saw. It went directly to the DOJ.
No, it did not go directly to the DOJ. It went to the Human Rights Commission.
Oh, Human Rights Commission. Okay, thank you.
That is my understanding. To the best of my knowledge, the Department of Education did not have access to those. There was a link on our website, and it went to the Human Rights Commission. Sam?
That webpage is there, yeah.
Yeah.
Representative Freeman.
Thank you, Madam Chair, and thank you, Attorney Fenton, for taking my question. So after it goes to the Human Rights Commission, walk us through the process, please.
It goes to the Human Rights Commission. It's investigated by the Human Rights Commission. I have no oversight
No, I understand.
in that world, so I
understand.
can't get into the details of that.
Okay.
If there is a finding, if there's a violation, if someone says, here, we found that there was a violation of 19340, then it would come to the Department of Education to review and impose a sanction on the credential holder's license, depending on the facts of that case.
Okay, follow up? Follow up. So through this process, from what you understand, the DOJ never comes into play. Is that correct? Either one of you,
Okay.
anybody who can answer it, I'm good.
I'm happy to try to answer. Thank you for the question. The DOJ may have a role to play. I mean, we certainly have a role to play in interpreting the law, and I appreciate Attorney Fenton pointing out our opinion, because that is on the website and that is the public guidance. We do have a role to play when we're asked to provide legal guidance to agencies in terms of how to interpret the law or how to implement the law. And we certainly have a role to play, and that's the role I play in defending laws when they're challenged. And we do that whether we agree with the law, whether we disagree with the law, whether it's susceptible to a challenge, or whether a challenge is completely meritless. I mean, that's kind of the role we play in civil litigation. So those are really the three hats that we might play in vis-a-vis a law like this.
Thank you.
Any other questions? Representative Woodcock.
Thank you, Madam Chairman. Good afternoon, ladies, gentlemen, attorneys. Mrs. or Ms., I don't know, the executive director, McKinley of the Cornerstone, said in her written statement and in her verbal statement that the DOJ consistently pressured the Department of Education not to even investigate any violations. I asked her, for example, if she didn't have any. Are you aware of being consistently pressured, Attorney Fenton, by the DOJ not to even investigate?
No, I am not.
Thank you. Sir, may I ask you the same?
No, I think the only thing that I'm aware of is providing guidance to agencies, both public guidance, like what Attorney Fenton mentioned, and guidance that would be subject to attorney-client privilege, but not something that I would understand to be consistent pressure.
Thank you all very much. Thank you, Mr. Chair.
If I may, I want to give a full answer to Representative Freeman. There is this civil rights unit with Attorney Sean Locke. So I know that the Department of Education, when these cases would come up, we would refer them to the Human Rights Commission, as I previously testified to. But we have also reached out and work very closely with Sean Locke. If an issue comes up, we'll refer it to him for consideration. He might then pass it on to Human Rights Commission. So there's a lot of back and forth with these state agencies. And I think to Representative Woodcock's question about pressure, it really is very collaborative in terms of our working relationship, whether it's with the Human Rights Commission or the Attorney General's office. It is, I have found in my experience, it's a very collaborative issue. And so they produce their technical advisory. What do you call it again?
There were two different, just to clarify, there were two different. There was an Attorney General opinion, and there were frequently asked questions that were released jointly between the agencies.
So we have had an ongoing rapport with the Human Rights Commission as it pertains to these cases, and the Attorney General's office as it pertains to these cases. But the guidance has always been very clear that the investigative part of it is handled by the Human Rights Commission or the Civil Rights Unit of the Attorney General's office. Maybe, I don't know.
I can't speak to that.
And then if there is a violation, it comes to the Department of Education. So I hope that helps to better answer your question. I didn't want you to think that we just bypass the Department of Justice, because we work very closely with the Civil Rights Unit there.
And I thank you, Attorney Fenton. Please don't take this the wrong way, but it's still as clear as mud. So I think, you've definitely made it clearer, but I do think that there are areas where it's still a little fuzzy and a little gray. Not for me, because you just sat here and explained it to me, but for the general public who may not know how to, negotiate this system. So, but I appreciate the fact that you both sat here and just walked us through the whole thing. I appreciate that.
And I will just say, Representative Freeman, I have spoken with a lot of really smart attorneys that I hold in very high regard. And they have said to me, so what happens? Who does what? I think it was a very confusing situation. I can't say I found the law confusing, but just the dynamics that it created. And so I certainly will say that I appreciate the Attorney General's office releasing their opinion or frequently asked questions that did provide a lot of guidance, not only to the Department of Education, but also to the field as to what agency is to do what role. So that was very appreciated.
I do appreciate that.
Thank you.
Representative Terry.
I just want to be clear. I realize we're not engaged here in a therapeutics or fix-it session, but thinking of this in terms of a flow chart. If somebody were to mistakenly attempt to file a complaint with the DOJ, then it's my understanding the DOJ would refer the person to the Department of Education. The Department of Education would then inform the individual, you have two courses of action. You can file with the Human Rights Commission, or you can file a civil case in Superior Court. And that would be the correct place. Now, somebody might get it right the first time if they happen to know the law. But if they didn't know the law, and they either went to the DOJ first or they went to you at the Department of Education, ultimately where that person would be directed would be to the provisions that are laid out, the requirements that are laid out in statute. Correct?
Yes.
Yes. This is like rules for dummies, so thank you.
Oh, no, those are the only rules I know, are the ones for dummies. But yes, we found ourselves in a position where we were routinely referring these matters to the Human Rights Commission or to the Civil Rights Unit at the Attorney General's office, yes.
Any other, Representative Balboni?
Can't hear. Can't hear.
It is on. It is on, but.
Hello?
Oh, there you go.
I'm back.
Imagine that.
What happened? Oh, so it's on that paragraph 3, section 3 again. It says there's 2 ways to do it, and you've referred to it. And we've talked a lot about if the link came in and then it would be sent to the New Hampshire Commission for Human Rights. But the other way, does that mean that the parents or the aggrieved individual would file a civil action independently against the school, and the state would not be involved at all, that first way?
I think you're talking about Roman numeral 3, correct? So yes, so there were really 2 options for enforcement there, and I just want to clarify an answer I provided earlier, which was with respect to the Board of Education. For a direct action, either in the Human Rights Commission or Superior Court, it was any person who claimed to be aggrieved by the law, or the Attorney General's office could do that in the same way that the Civil Rights Unit enforces laws under 354A. But so yes, any person could go into court and do it in that way. It's the Board of Education process that then comes after that, as Attorney Fenton was talking about, that once there's been a found violation, then a Board of Education action can go forward before the board.
Hello. So do you know if we talked a lot about, that nothing really happened the other way. There weren't any violations or any cases filed. But the first way, if they went to Superior Court, do you know of any instances or attempts filings that went through Superior Court?
Agreed by the law. Ultimately, the federal judge declared the law unconstitutional, so at this point it's not enforceable in light of that order. So none of those ultimately came to any fruition. I'm not sure even if there was a finding of probable cause, but there were some that were filed.
Representative Litchfield.
Thank you, Madam Chair, and thank you for taking the question. So, if I'm understanding correctly, the judge ruled that there were 3 areas of vagueness. This amendment addresses the 3rd issue, but the first issue, conduct that is being prohibited, and then the second penalty needs to be more precise. Do you have suggestions on what we can do to improve this amendment? Or I realize that we may be catching you on the spot. Is this something that
Representative Litchfield?
Oh, is that not a question?
I don't believe that they can give us suggestions on how to change.
Oh, sorry. Just kidding.
Although we would like you to do our work for us. Any other questions? Yeah. Seeing none, thank you.
Thank you so much.
Representative Corzine.
Good afternoon. My name is Lori Corzine. I'm a state rep in COA 7, but I want to testify today just for myself, not for my constituents. There was a time 4 years ago, I was contacted by one of the parents up in the North Country. And one of the teachers at the local high school was, she's a language arts teacher. And they were reading a book. And the book included Christian missionaries go into a tribe or something and whatever happened. Anyway, she wrote on the board, Bible thumping crackers to refer to the Christian missionaries. She then continued to refer to the Bible thumping crackers, or BITCHs, as that word. Now, this parent actually gave me pictures of her writing this on the board. She also had a video of the teacher referring to the Christian missionaries as the B word. This parent came to me asking for help. I had no idea what to do. I did end up sending letters to each of the school board members, to the principal, to the assistant principal, and I was stonewalled the entire time. One of the superintendents actually said she would get back to me. She didn't. I wrote back probably about 4 days later, and I said, the parent who sent me this, her child isn't comfortable in class anymore. They were a Christian family. And they refused to help. I kept asking, where can I send a letter? Plus the pictures, plus the videos. I think things like this are necessary. I would love to say all teachers are there just to teach, but there's a lot of ideology that's getting in it, and it is making kids uncomfortable. And no family should have to send their child to hear that, Christian missionaries are the B word. I think a bill like this is important. That's all.
Thank you. Any questions? Representative Morse?
Just to clarify, you're against the original bill, but for the amendment?
I am for the amendment. No, yes.
Thank you.
Thank you.
Yep.
Yep. Is there anyone else who wishes to speak on this bill? Seeing none, we'll close the hearing. Two breaths. Oh.
Sure. Yeah.
Representative Terry?
Wait a minute, please. Representative, allow me.
But it's your job to remind the person who needs to change the sign.
This is really citizen legislation. I mean, no staff here to change the sign.
Yeah,
Unfortunately, I didn't know where you put it, though. Is it over here? Is that where it goes? Okay. forgot to give me my pink pen.
I just want to wait a few minutes to start the next hearing because he's going to check on the microphone so that we don't have.
I'm not going anywhere.
One, two. Hello?
Hello,
Doing
hello.
test,
Now it's on.
testing, 1, 2, 3.
Testing.
Oh,
Hello.
oh.
1, 2, 3,
One at a time.
4, 5, 6. Okay, he just said I'm number one. Thanks.
Did you turn it on?
Did it work?
Hello, hello.
Can you?
So, am I number one?
Testing.
Yeah. You can hear.
Now I am.
I can't, you're not on. Yeah.
Hello?
Yeah, you worked.
Hi.
Hello.
Goodbye.
Can you hear me?
Testing.
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 Hello, hello, hello? Anybody in there?
Hello.
Pronto.
Yeah, we're live.
Pronto,
Okay.
please.
I'll let media know we had some glitches, but they might be able to come in once we're finished today.
Pronto, pronto.
We'll open the hearing on HB 695 FN relative to school districts and medically related grants, and I welcome the prime sponsor, Representative Perez.
Thank you.
Good afternoon. For the record, my name is Representative Christine Perez, Rockingham 16, representing the town of Londonderry. Last time I'm before you this year. This is a very simple bill, and I have submitted an amendment to you. The amendment only changes words from school to school districts and from a legislative body to the municipality of a school. So basically, this is to require the school districts to form a policy, to adopt a policy concerning the acceptance of grants or seeking grants for medical products or services or funds that unless the town votes in favor of it. Once again, this clarifies guidelines for in-school employees and make sure that families are aware of any such procurements that are being that are in the schools. And you could ask why. Well, there's several reasons why. Parents in the community should be aware of such services and have the option to approve or not approve it. And schools are typically not in the business and should not be in the business of healthcare in circumstances for their own protection. The only healthcare provider that you really have in a school would be your school nurse. Grants usually have an end date on them, at which time the money needed for the continuing the service or the procurement of such things would fall onto the taxpayer. So therefore, they should be aware of a grant. I can equate this to it when you ask for a 3-year grant to bring on perhaps a new a police officer. Once that 3-year grant is done, then the salary and for that falls on. So people should be aware of any type of grant for that reason. I really have nothing else to say about it. It's fairly simple, but I'm more than willing to take any questions.
Representative Morse.
Thank you, and thank you for taking my question. My only question here is regards to first aid, AEDs, and like EpiPens. I know we passed a bill recently about epinephrine injectors. Would this also, in essence, prohibit those types of grants from being made unless the school body? Go ahead. Yeah, unless the school body approves.
I'm going to be honest with you. I don't know. I think as far as your AEDs, those are donated usually. I know our fire department donates them to them. As far as actually medication, I don't believe that this would fall under, medications would fall under this, but I'm not exactly sure, to be honest with you.
Representative Hall.
Madam Chair, and thank you for taking my question. I'm trying to figure out where this came from. Like, what precipitated this idea that this was necessary?
I actually was asked by a couple of other legislators to do this in other towns where there had been issues, and I'll go all the way back, okay, where I think partly this came from. During COVID, there were multiple school districts that were thinking of or talking about bringing in providers to offer the vaccine for kids. I know my district was looking into doing that too. I know it was stopped in a lot of them. There are several towns in New Hampshire that actually, cities, I take it back, cities in New Hampshire right now that actually have medical facilities within their within their schools. I know Maine is having a big problem with that as far as lawsuits are going on because of that, because of lack of parental notification about what services in those inside the school are being offered by, actually it's mostly hospitals that are actually putting them in. There's lots of lawsuits going on right now in Maine that were brought to our attention. So I think it is for the protection. Schools are not in the healthcare. That's not their service. Their service is education. Your healthcare providers in the school are nurses. There are strict guidelines on what a nurse can do. There's strict guidelines about what a social worker can do within a school. So I think that this is protection for the parents, protection for the children, but I also think it's protection for the school so that if something happens within the school because of something being brought in that is not directly related to its what it's supposed to be doing, it opens it up for lawsuits. So,
Thank you. Can I ask a follow-up?
does that answer your question?
One second. Okay, the question is, yeah, it did actually answer my question. You did say that it's okay unless the town votes in favor.
Correct.
How does that happen? A warrant?
Warrant, sure.
Every single, anything, any grant, you have to have a warrant number.
Representative Hall, may I ask where you're from?
Both.
Both. Well, do you have, if you're getting a new police officer, do you have it on the warrant article to accept it?
Okay.
I'm sorry, is that inappropriate?
Yes, you're not supposed to ask.
Questions are going in this
Okay,
direction.
okay, sorry. Yes, it would go on the warrant article. It would go on the warrant article to accept the grant, similar to if the town received a grant for 3 new police officers for 3 years, that type of thing. That's,
All right.
I think that's the clearest one.
Thank you.
Representative Woodcock.
Thank you, Madam Chair. I just a clarification. You're talking, I understand about, are you addressing the amendment as well? Because the amendment's different, and I hear you crossing back and forth with some of your language.
The amendment is, I do not believe that the amendment is different. The amendment says, it changes it from schools to school districts. So, which was a clarification because it really should say districts because it would be the entire district voting on the grant. And it changes the words of, poorly put, that it would be the legislative, which is a legislative body of the school district, which is the people in the school district, to the citizens of the municipality.
Madam Chair, may I finish? May I follow up?
Follow up.
Well, I understand what you're saying, but it's the reverse. The bill says the municipality. The amendment says the school district.
Right, well, it
So it's
does.
not the citizen, you have the bill, the citizenry.
Right, I'm sorry.
That's why I'm getting confused.
I apologize.
That's okay.
I apologize.
That's okay.
Yeah.
But you keep on
So,
crossing back and forth.
I apologize. So it's the legislative body of the school district. I was told that would be better wording than the other wording,
May I
the
follow my
initial
question
wording. I apologize.
But now we know where we are. Okay,
I
thanks.
apologize.
That's okay. That's okay. I make it all the time.
It's been a long day across the hall.
Yeah, but it was. So going back, if I may go back to that, just I sort of had 2 parts. At the conclusion of the amendment, he said in line 7 and 8, unless moving to the last 4 or 5 letters, the school district votes in favor of the proposed action. So basically, there's the first part of the amendment says no, unless the school district, that would be I'm guessing the school board, because
No.
they're the legislative body of the school district. The school board is the legislative body of the school district.
This needs to go before the town.
It doesn't say that. It says unless the legislative body of the school district votes in favor.
I'm sorry, I'm crossing my wires again. Yes, it needs to be approved by the legislative body of the school district, which would be your school board.
Okay, so
I apologize.
that's okay.
Yes.
Madam Chair, may I finish?
You might have another question.
Well, the same question, just
Okay.
trying to get the right words. Okay.
Gotcha.
So so in that case, if they vote one way or the other, they can
Pass it.
overrule
They
the
can take
policy.
it, right.
So I wanted to go back to my original question, which was the medical products. They can't apply for grants or accept grants. We just have dialogued this last session and even now this year on EpiPens.
Right.
And generic EpiPens.
Yep.
And they're not free. They're
There you
grant funded. So for the most part, so this, the beginning of this would say they can't even apply for it.
No, it's saying that they cannot acceptance of medical products. They need to, unless
No,
the
it's-
school
may-
board.
May I, Madam Chair?
Yes.
Okay,
Oh.
going back to now let's go back to line 6. It says the policy prohibits school districts from seeking grants, so they can't apply. If they can't seek, they can't apply. You know what I'm saying? It says you can't seek a grant.
It says you cannot seek or accept
Okay, seek.
or unless approved by them.
Okay, you,
Representative Murray.
Thank you, Madam Chair. Thank you for taking my question. So in the event that a school nurse would
Can't
want
seek
to pursue an opportunity to even just look at potentially like Band-Aids or some other type of need within their charge, you're saying that first it would need to be fully approved by the school board to even pursue that versus reaching out to the superintendent or the school board. Many times there are processes within a district. If you are looking to have a grant fulfilled in some way, you fill out a form, the administrators take a look at that. So you're saying that that process would not be in place unless the school board would approve each individual instance?
It's my understanding that right now, schools do not have policies around procuring even Band-Aids, okay? This is to prevent going from asking for Band-Aids to asking for things that would go beyond, far beyond the treatment of a bruise. It's going to say, if we say you don't need anything, that you can get grants for anything, okay, without anybody's approval, okay? We can go from Band-Aids to having an approval to have a medical, to having a medical facility without the approval. It's to bring it together so that there's oversight on things that are being brought into the school that are medically bound, not educationally bound.
Representative Murray.
Madam Chair. So is it your assertion or belief that there is not a process currently at all for grants?
No, I think might be a process for grants, but for medical grants, I'm talking about we need to make sure that there is a strong policy for medical grants because we do not want, I believe, schools getting in the business of medical treatment.
Representative Freeman.
Thank you, Madam Chair. Thank you, Representative, for taking my question. So this only applies to grants. This does not apply to regular medical first aid, period. Is that correct?
Correct.
Thank you.
okay.
Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. Is your opinion that this medical services would include mental health, educational services, psychological services? A lot of those are provided under federal grants to the schools.
They are, but it's my understanding that the grants still have to be approved. Everything should be approved so that people are aware of what is going on in the schools. I was an intensive care nurse intensive ER nurse, recovery room nurse for 42 years. There is a huge difference between education and medical issues. This is to protect parents, teachers, staff, and students from things being brought into the school that may step over a line of what is appropriate to be into a school.
Representative Damon.
Thank you, Madam. Excuse me. Thank you, Madam Chair. Thank you for taking my question. I actually have two. Does this or would this apply to grant funding from a state agency? For example, from the Department of Health and Human Services might have grant funding available for some aspect of medical products or services. So does this apply to grants from any entity, including state or federal?
Absolutely.
Okay. I've momentarily forgotten my second question. I'll come back.
Representative Litchfield?
Thank you, Madam Chair, and thank you for taking the question. So originally I was excited because I had thought that you were saying that you wanted this to go before the legislative body, as in the voters, because, so my question is, I just want to clarify, because my feeling was, that's great, because so often we get these large grants, and then when the grant runs out, all of a sudden we're expected to absorb these into the budget, and it could be six figures or more.
Correct.
So I just want to clarify, do you mean just the school board, or do you mean the actual legislative body that votes, let's say, at deliberative session or at the school district meeting?
I had originally put it in as the citizens of the municipality. I was advised that in order to make it more palatable, I'm being honest with you, that it should be the legislative body of the school board. I know. It's called bringing it to make it more palatable.
Follow up? Yes, please. Thank you. And thank you. I just want to clarify because I'm wondering if maybe an amendment is in order. So you're saying, as Representative Freeman asked, that they could apply for grants that has anything to do with emergency supplies, emergency medical supplies, but no.
No, that's not.
You can't apply. Well, so you do not want them to be able to apply for emergency supplies? Okay, wait a minute. So, okay, but
Okay, guys, I'm sorry, representatives. One question at a time.
May I tell you a story about Maine, what's happened in Maine? No, okay. I'm trying to protect, I literally, my intent is honorable and it is to protect.
Representative,
right.
Hold, please. State your point, please.
Madam Chair, was there a question related to, was this a request of any of the membership here?
Or what?
I'm sorry.
The bill?
The story?
Where was it in response to a question that was just asked? I thought we were talking about the amendment or potential amendment.
Correct. Do you have a question? Representative Morse.
Thank you, Madam Chair, and thank you for taking my question. Earlier in your testimony, you also mentioned about the things that are happening in various states, and this would be kind of more of a proactive way to stop stuff like that from happening.
Right.
You mentioned specific to Maine, and some of us have heard what is happening in Maine, and would you like to clarify a little bit about that?
Maine, it's my understanding that Maine has, in several areas, they are actually having different hospitals putting clinics within the schools. And the story that some of us heard during was the story about a group of young girls, 15, going and saying, okay, let's all get birth control. Nothing matter with that. It's legal. But the problem is that the pharmacy provides it. The parents don't know, which is legal. And they had a case, and there's been other cases, but the one case that struck in my mind is that a young girl had an injury that required surgery, and no one knew that she was on any type of birth control. And
Representative Perez.
yeah,
could we just talk about grants, please?
Okay. I thought he wanted the story. Sorry.
Any other questions? Representative Cornell.
Thank you, Madam Chair. Thank you for taking my question. In the methodology, this said this could affect federal grants also.
Yes.
And so, in 24-25, our federal grants totaled $116 million. So in effect, if we don't get these federal grants, does not that cost of providing services fall to the taxpayer in the local community?
Do we get grants specifically for medical products?
I really am not clear of what you mean by medical services and medical products anyway. So I think that if the Department of Education says this could impact federal programs, IDEA, Title I, Title I-C, Title I-D, McKinney-Vento, which affects homeless people, if we're going to lose $116 million,
I do not believe that is the intent of this. The intent
But it
is
would
at
be a result of
at the school district level to protect the schools.
Representative Woodcock.
Thank you, Madam Chair. I just want to go back to Representative Perez, and I appreciate your testimony the other day, particularly your background in emergency services was really valid. But in this particular case, I'm concerned where protocols in schools, having been in the school business for almost 40 years, too many, almost as many as her, that I've never seen a grant submitted without approval of the superintendent and the school board. I heard you use the term strong policy. Local school boards have those policies. I worked in Maine, in New Hampshire, and Massachusetts, and never, ever have I seen a grant come from a teacher or a school administrator without going to superintendent and then being approved by the school board. Different from seeking grant or looking for money, additional monies. So are you aware of any grants in New Hampshire where they bypass the superintendent, bypass the school board and gone directly to, I've never seen it in 40 years.
Thank you. No, I haven't seen that, but I also was shocked, as when I was here before, that there was no policy for emergent care. So these are medical grants. These are not educational grants. And your superintendent and all are, and teacher and superintendent and school board are not necessarily medical people. They are educators mostly, but not necessarily medical. It's separating the educational grant from a medical grant.
My point was not that it's separating anything, because the process is every single grant has to go through the school board. I think in reality, you're talking about services. The intent of this bill was to identify services that may or may not be happening in some schools that you believe happening during the day. But the rest of this is really confusing what you're trying to get to, because you're restricting schools and you're putting processes already in place. You know what I mean?
Are we sure they're in place?
Thank you, Madam Chair.
Representative Damon.
Thank you, Madam Chair. So in the past, like 25 plus years ago, probably, a local hospital in my district opened a clinic to provide preventive health care and wellness care to teens. And they leased space from a public high school to do that. The school had space not being used. The hospital wanted to bring services more conveniently to where the students generally are. That particular clinic doesn't exist anymore, but I think that's not an unusual model in many states. Yes, thank you. So how would this proposed legislation impact a clinic run in a school facility, but not run by the school? So the hospital or other entity, medical providers, are simply leasing the space, and then they may well want to be obtaining grants.
If they're leasing the space, they would certainly need to be able to get approval, correct?
Approval for the lease?
Approval to have the space within the school and for the
Representative
lease.
Perez.
Yes. I can ask a question. Okay.
Yes, thank you.
Clarification. Okay. I'm going to be perfectly honest with you. We should not be having medical facilities within the schools. That should not be happening, in my opinion, having been in medical facilities. So we should not be having them in the schools. Schools are for education, in my opinion. I want to stop us from running into trouble.
Talking about grants. Any other questions? Thank you.
Thank you.
Becky Wilson.
Good afternoon, Madam Chair. I almost said good morning. That's how this week has been so crazy, all of you. Thank you for hearing my testimony today. For the record, I'm Becky Wilson from the New Hampshire School Boards Association. I have not seen the amendment, so I cannot speak to the language of that. I am going to ask a couple of clarifications. Oh, thank you, Representative. Much appreciated. Regarding the original bill, and I will try to doubly read and ask questions about the amendment as well, or bring up concerns. Our reading of this bill, I think in its interpretation, at least the original bill, this absolutely would impact districts' abilities to procure things like EpiPens, Narcan, AEDs, and even still, I do believe, supplies potentially for the nurse's office or for jump kits, or, you know, those things that you take in an emergency situation, the buckets, etc. CPR courses or post-concussion impact testing. Line 5 does say any related money is procuring medical products or services. So funds to procure them. That's any funds. I believe it says or funds, so it doesn't say and. I'm not sure. I realize that may not have been the intention of the sponsor of this bill to cover all of those things, but I believe the way that it's written in line 5 that it would certainly impact all of those things, not just grants. I share the concern around the wording of it shall prohibit schools from seeking grants. So I'm not sure how a district would turn off their ability to seek a grant. I mean, we are constantly getting information from the Department of Education, for example, from other partner organizations who potentially are putting out information about grants that could be available to school districts. I don't know how you don't then, you just, I guess, ignore those emails and documents coming from the department. If you're not allowed to even seek them out or to get more clarification about that, it's a little bit concerning, that wording in there. I also share a concern about the fact that this seems to be stating that you could not accept or even apply for a grant unless the voters vote that you can do that. That typically is in March. So what happens if a grant opportunity comes out in August and the deadline to apply for that is October? Then the districts are just not applying, I would imagine, or they're going to wait till next March to ask a question that's irrelevant at that point. Do you call a special meeting? I'm not sure how that would exactly play out. I will just, I won't go down the rabbit hole. However, I will speak to this issue about the programmatic concerns from Maine. That specific grant is called Community Schools Grant. I think we've spoken about that in regards to a different bill. However, that grant was put into the Maine state budget by the Maine legislature for 5 schools to participate. So that is why those 5 schools are seeking those grants. It was a legislative action that was taken by their legislature to try to build those community partnerships within their state. So it's very specific. However, it also, community schools cover 24 different things that they are bringing to the school district, of which one is a primary care service model in partnership with local health agencies. So there's 23 other things that come with community schools. It is not solely about medical services in schools. And just to clarify, New Hampshire, I think, currently has 4 community health partnerships or community health organizations that are, I think, to the previous speaker's comment, for lack of a better term, renting a space in a school district to provide convenient primary care services to families who are using that as their primary care servicer. I believe those are Somersworth, Newport, Manchester, and Rochester. They are partnerships with hospitals or other medical entities. They are not run by school staff, as I think we talked about in other bills. I do have a question about whether or not this would impact the district's ability to accept funds even from our state Department of Education, that is the flow through for federal grant monies that potentially could be tied back to some sort of medical service or product. Does this affect medically necessary services that are being provided at school for students through IDEA that fall under Medicaid to schools? Would that mean that we could not, as a district, participate in Medicaid to schools? Would it mean we can't take IDEA funds from the flow through at the state level to cover students' medically necessary services like occupational therapy or speech? And just to clean up the fact that there's a concern that when grants go away, districts have to hold the bag for whatever they've put in place. Certainly that is always a concern. I think we've heard a lot about that over the last couple of years in regards to the ESSER funds, because that was such a big influx of funds to districts that we knew was going to go away. There is a criteria in almost all federal grants called maintenance of effort, where the district has to consider what portion of those services that you're obtaining with the grant you are going to put into your operating budget at the start in order to maintain your effort to continue to provide those services. It is not fair to families or students or staff to give them something and then just blanketly take it away when that money runs out. So that maintenance of effort is something that's required in almost every single grant application, and it is meant to be protective to the district and to the families of the district so that that cliff doesn't happen and those services that you've been providing don't just go away, on the positive outlook that those services are being helpful to students and families. So I'm happy to take any questions.
Thank you. Representative Murray?
Thank you, Madam Chair. Thank you for taking my question. My question is around sort of that grant process in general. Is it a common practice first to, if a nurse or any other entity is seeking a grant, they would first go to the superintendent and discuss the desire to seek a grant?
Thank you for the question, Representative. There are multiple kinds of grants. I mean, obviously, there's grants that are obligated to you from the department as the flow through, things like IDEA, Title I, your title grants, et cetera. Those typically don't have reapproval every single year. You know that money is coming, you know what you're going to be given by the state. And so those have a somewhat different process, I would say. Competitive grants are something different, where obviously those are put out on an ongoing basis by lots of different organizations. In which case, yes, if anybody at a school level is seeking out a grant, it is almost never that the school can submit the grant without some sort of approval at a higher level, whether that's the superintendent and the school board. The school board would have to vote to accept those funds at some level if they were to be provided the competitive grant, if they win the grant. All of those things have to be accepted in terms of school board's ability to manage federal funds and other kinds of funds. There are priority policies that are required by law. In New Hampshire, policy DAF, administration of federal grant funds, walks you through exactly how those funds need to be managed at the board level. And there is also a policy that is mandated by law, JLCE, which is in regards to emergency care at school and what to do, what school boards can and cannot do, what staff can and cannot do in regards to an emergency medical situation, and to try to, put the minds of some other people at ease that it's very clear what a school board or school staff can do in an emergency situation in terms of medical care and things like that.
Any other questions? Seeing none, thank you.
Thank you.
Emma Savini.
Good afternoon. Thank you for hearing my testimony. For the record, my name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonpartisan, nonprofit organization that solves problems through policy change. We are here in opposition to House Bill 695 as written, just because of a few concerns we have with the language, specifically that medically related is not defined. To one of your points, I can't remember who brought it up. It's unclear to us whether or not this involves mental health services that are often grant funded and really do a lot of work to partner parents with the schools in connecting them to services outside of the school. In a situation where we have a huge workforce crisis and parents are facing really long wait lists, it's helpful to have those services available to students both in school and out of school when parents need the services for their child. The other component to this that we're concerned about is the prevention piece. There are state organizations, the Governor's Commission, that have grants that go, I believe, to schools for prevention of substance use and other risky behaviors, risky health behaviors. So I think it's important to make sure that those grant dollars are still available for programs that students, parents, and schools rely on. Happy to take questions.
Thank you. Any questions? Seeing none, thank you.
Thank you.
Is there anyone else who would like to testify on this bill? And we'll close the hearing for HB 695. Wait, what time is it?
Well,
we have till
time for the
3.
next one.
No, 2:45. Oh, it's 2:45.
Yes,
Why
but-
did I think it was 3?
Yeah, because it was 1, 2. Yeah.
We'll open the hearing on House Bill 324 FN relative to prohibiting obscene or harmful sexual materials in school, and I welcome the prime sponsor, Representative Cordelli.
Thank you, Madam Chair. For the record, Glenn Cordelli representing Tufton Borough, Wolfboro, and Ossipee in the beautiful Lakes region. Some of you who were here last term might remember this legislation from last year. It is basically the same legislation, and I think it is needed legislation because what we've seen around the nation, but also here in New Hampshire. And I happened to see this one story the other day. A Maine 6th grade student, 11 years old, testifying at a school board meeting about a pornographic book he found in school library. And in his testimony, he said the librarian asked him if he wanted a graphic version of the book. That's an example of why we need this legislation. And this legislation addresses age-appropriate and materials that are harmful to minors in schools. And there are three basic components to the legislation. The first is Section 1 at the top, which is our criminal statutes, 650 statutes in particular. Right now, educational institutions are exempt from our obscenity laws. Let me just mention that obscenity is not protected by the First Amendment. That was the Roth versus United States Supreme Court decision in 1957. This legislation alters that exemption to maintain an exemption for higher education, but not K-12 education. The second section really deals with the harmful materials to minors and the definitions. These definitions are taken from court decisions originating with New York penal law, and there are definitions on the first page, and over on the second page, you'll see the definition for when materials are harmful to minors. That's in Roman 2 on page 2. Again, this has been upheld by the U.S. Supreme Court and is in 20 U.S.C. Code 9134 F7 is where you can find them also. And I think that's very important. And I'll just mention that I worked with the New Hampshire Attorney General on this legislation and these definitions. The third main component to this bill starts on line 20 on page 2. Now I might be looking at a different version than you are, but it's 18976, the complaint process. It should be on the second page as well. And this lays out a minimum requirements for complaints. We have so much in statute about parental involvement in education. It's right at the top of our statutes on education. And parents need a way to address the situation when they find materials that are harmful to minors. And this lays out the minimum process, starting with complaints to the principal, then appeals when necessary to the superintendent and to the school board, which is over on page 3. And finally, the parent, if they have not received satisfaction at that level, they can appeal to the State Board of Education, which is their right under existing law elsewhere that has just been referenced here, in that RSA 21 and 11, under the duties of the school board, Roman 3 says, hear appeals and issue decisions which shall be considered final decisions of the Department of Education of any dispute between individuals and school systems. So this is a right of parents to continue their appeal process up to the State Board of Education per law. And there are time frames provided for each of those steps in the process. The fourth section of the legislation is 189.77 in enforcement and penalties. And this is a civil section. In my discussions with the Attorney General, he admitted that it would be very, very rare for a situation to escalate in a school to a criminal case. So we added this civil section, and I'll just say generally, my thought that if there is no enforcement in legislation, it's really just a suggestion. So we have this enforcement mechanism. Under two conditions can a civil case be launched, and that is when the decision of a school or school district or the school board has not been adhered to. So if the superintendent says, yes, this is age inappropriate, should not be in a middle school, move it to the high school, or this shouldn't be in our schools at all. If that is not adhered to, the parents would have civil action. The other option is that when, basically similar to that, in that the material is made available to the minor in a manner that's not consistent with the final decision. In either case, the petitioner could be awarded general or special damages by this civil action. So I think that this is reasonable legislation based on all the instances we have seen. Many of you who were here last term on the Combined Education Committee remember that there were many examples of these types of materials handed out in our committee with members refusing to look at them, even though that they were in our schools. And on the House floor, members reluctant to hear from these materials that are in their schools. So I think that parents need a mechanism, and this legislation is intended to provide a minimum process for resolution of parental complaints. Thank you.
Thank you. Are there any questions? Representative Nato.
Thank you, Madam Chair. Thank you for taking my question and bringing this forward to us. So I had a question on page 2, line 36. Throughout the school principal or his or her designee shall determine whether the material is the subject of the complaint is harmful to minors. Do you think it should be more brought to like the school board and not just have one person making that decision?
That would be part of the complaint process. If, start out with the principal and when necessary, go up to higher levels up through the State Board of Education. But I think it's reasonable to start out at the school level.
Thank you.
Any other questions? Representative Hall.
Thank you, Madam Chair, and thank you for taking my question. Is this for only public schools or public charter schools or private schools, religious schools? They're all schools.
It's public schools and charter schools, public schools. Yeah, I'm not touching with this legislation non-public schools.
Follow up. I'm just wondering about the charter schools. I thought Attorney Fenton had said that it needed to say charter school. Does it say that somewhere? Maybe I missed it. No?
Yeah, I'm not sure if this does say public charter schools or not, to be honest.
Okay, thank you.
Representative Murray.
Thank you, Madam Chair. Thanks for taking my question. I did have a question. I believe I thought I heard you say that you were referencing on page 2, line 20, under the complaint process, you had said 189.76, or was I mishearing that?
I'm not sure if I did say that. I might have said that, but I was looking at a marked up version
Okay.
of the bill rather than the one that you're looking at.
I see. And follow up. If I may. Thank you. Additional question. Do districts already have challenge policies in place if they find objectionable material, if a parent feels like there's material that is objectionable? Are you aware of any districts who already have that?
I believe there are districts that have a process. I just want to make setting a floor, if you will, in terms of that process, and make sure that parents are aware of their rights to appeal to the state board as well.
Any other questions? Representative Cornell.
Thank you, Madam Chair. Thank you for taking my question. Isn't it already against the law to give these kind of materials or make available to minors these kinds of materials?
I'm not sure where it is against the statutes in New Hampshire, but I think that what we need to do is lay out a minimum complaint process, but also set an enforcement mechanism when required. And I don't believe that that's anywhere in statute.
Well, another question. Thank you for taking my question. So it said that there would be damages of $1,000 for each violation and costs and reasonable legal fees. Who would pay that? Would that be the local district or the taxpayers who would have to pay for that if there was found?
The school district. But
The school district is the taxpayers.
correct. Yep.
Thank you.
Representative Murray.
Thank you, Madam Chair. An additional question on page, I think this is 1. Yeah. With regard to line 19, subsection that defines nudity here. Nothing talks about sort of science or the process for which, conversations with communities who may not wear clothes, or science or biology, human biology. So I'm curious to know, you're simply defining nudity in a non-educational context, but I'm just unsure of, in a human biology class, if there were conversations about,
Right.
would that violate this?
No. I think that these are all taken from U.S. federal court decisions. All these definitions, and I think one of the cases might be Ginsburg versus New York. But this is not instruction in biology. These are materials that are harmful to minors, as indicated elsewhere in the statute. not statute, but in the legislation. I think that's on page 2, page 3. No, page 2. I was wrong.
Representative Hall.
Thank you, Madam Chair. And thank you for taking my question. Just to follow up to Representative Murray's question, like art classes, Statue of David, I mean, you can't do that anymore?
No, that is not the intent of this. I don't think that those things like that would be indicated as harmful to minors per the legislation or per court decisions.
Representative Dry.
Thank you. Thank you for taking my question. Reading a little further, it seems to me that something in order to be declared harmful has to meet all 4 of the elements 1, 2, 3, and 4 on page 2 to be that includes nudity in one of them, but not all 4 of them to be declared obscene or harmful.
That is correct.
Thank you.
Representative Hall.
Thank you, Madam Chair, and thank you for taking my question. My question is about, this is about minors.
Correct.
And in our schools, we have students who are not minors. So what happens to their access to materials? Is it in the library, but only if you're not a minor?
I think that I assume that you're talking about at the high school level, probably. If that 18-year-old or 19-year-old, they would not be a minor, so they would not be covered under this. So they would have access to materials. But someone else who was 16 or 17 years old could complain about this or have their parents complain about this material. So if the librarian, let's say there was a complaint by a 16-year-old's parents, and the material was found to be inappropriate for that age group, then they should be, I would imagine that it would be possible that the library would move that to a separate section that would be available to someone who was of older age.
Okay.
Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. On page 3, line 21, that's section 7 there, it talks about the appealing to the State Board of Education. It says that an aggrieved parent, I think it's supposed to be aggrieved parent or guardian, may include a parent or guardian who is not the original complainant, but one who is the parent or guardian of a student for whom access to material is determined to be removed or restricted. My question is, as an example, if somebody takes it all the way up to the State Board of Education, a particular book, State Board of Education says this book is not appropriate for this age level, does that mean that every school district has to abide by that decision?
I would think certainly that school district would, and I would hope that the state board or the department would make it known that that material was not appropriate for a certain age level to other schools as well.
Follow up, please. So if I'm understanding that correctly, somebody could say, I took this appeal to the State Board of Education in my town, Rye, and they said it wasn't appropriate for the age level. Somebody could take that information and then say, okay, I'm going over to Hampton, and they've determined that it's not appropriate. The State Board hasn't determined it's not appropriate for Rye. They can do the same thing, and so it would just kind of bounce around so that one book that was challenged wouldn't be available statewide.
I think there would have to be, communities are different. All right. So I think that the appeal process would go through in that Hampton, for instance, that other district as well.
Any other questions? Seeing none, thank you. Okay. Yeah. No, I'm going to put a 3-minute time limit on for the rest of the testimony. Representative Perez.
Good afternoon. Thank you. Thanks for hearing from me again. A couple of things I wanted to bring up along with this. I am in judiciary, and we have a bill that has made it through judiciary. And I think most parents and most people are not aware that if your child, minor, takes a book out of the library, either at the school or at the public library, you as a parent have no right to know what book they have taken out. You don't have a right to know. Now, if you get a notice that the book is overdue and you owe money, and you call the school or the public library and ask, well, what book is overdue? They cannot tell you. And I don't think people are aware of that, but we have a bill that made it through judiciary that will change that. That's one thing. The other thing that came up that was very heart-wrenching in judiciary is we have a bill there that talks about children's access to parents being able to put filters on their children's phones and their iPhones and their iPads. And those filters are there, but parents have to access them. Well, we have a bill that says those filters will come on the phone for minors, and parents will have to opt out. And the reason why that came was because of parents of children. It's hard to access, to put those filters on, to make it better for the parents and better for the children. So that being said, I think this is common sense. I cannot take a 10-year-old to an X or an R-rated movie. I cannot take a 10-year-old into a store to buy a Playboy. When I watch TV in the evening, it has things on it that say, under 14, that type of thing. There are video games that a 10-year-old cannot access and cannot buy. To have the things in the school that are in the schools that children have access to, and as we know from last year, everyone was horrified when Representative Cordelli started to talk about them. Stop, you can't say those things, but yet those things were available to children. These are our children. One of the stories that we heard in judiciary over about a young boy who was accessing, thank you. Please vote for this. Protect the children.
Thank you. Giles Bissonnette.
Thank you, Madam Vice Chair. My name is Gilles Bissonnette. I'm the legal director of the ACLU of New Hampshire, and we're here in opposition to this legislation, and I just want to make a few brief points because I know I have 3 minutes and certainly want to be respectful of the committee's time and the opportunity for those behind me to speak on this bill. The first point I want to make, and it was referenced with respect to one of the questions, is about what is the connection between this legislation and existing law. And I did want to flag for this committee that New Hampshire law already prevents giving minors, quote, harmful materials. And I put that in quote because we have a separate statute, 571B, that defines harmful materials and wholesale prohibits that dissemination to minors, both in the school and outside of the school context. And there's definitions baked within that statute that are designed to codify and be consistent with the constitutional protections that we have and the constitutional standards that courts have articulated, including the Ginsburg case that the sponsor articulated before. So I just want to be very clear about that and want to encourage the committee to review that statute, because I do think in light of that statute, this bill certainly in my brain kind of just presents some questions, which is, is the intent or does its scope is it intended to go beyond what exists in the existing law? And that actually would be concerning because, right, the existing law, the harmful material statute, creates and embodies constitutional standards. And if we're trying to restrict materials beyond what exists in existing law and beyond what exists in those constitutional standards, there could be serious constitutional concerns. So I just wanted to flag that for the committee. I do think, again, begs the question, do we need this if we have existing law? And I certainly think it's a legitimate question with respect to what, if anything, is this intended to do beyond existing law. So I'll leave it at that. But I do want to convey some of the constitutional or some of the standards that are in this law and how they may not be fully consistent with constitutional principles. First, I just want to talk a little bit about the definitions in it, including its expansiveness insofar as it encompasses nudity and sexual excitement. I'm not entirely sure what sexual excitement means, but in any event, that exceeds sexual conduct. Sexual conduct is the obscenity standard that is used throughout the case law. It is the standard that's used in existing law in New Hampshire in the harmful material statute. So I just wanted to point out to the committee that this does go beyond that standard. And that's just one of a couple examples of, I think, one of the problems definitionally with this law. Lastly, I would want to talk about the State Board of Education piece, because I do think that's meaningful. Typically, when we think about obscenity, we think about local standards. State board is a state standard. They're not elected. And Section 1, with respect to obscenity, I also think is problematic and would apply to private schools. Thank you. I'm sorry for exceeding my time.
Will you take
I had to rush. Of course, absolutely.
Representative Drive?
Thank you, and thank you for taking my question. You still have time to get to your...
Sure.
Okay. I understand that it is already harmful, a crime to show this material to minors, but what we're talking about is the immunity that educational institutions have from that law. And I think that K to 12, made up of minors for the most part, 99%, applies here. So why do you have a problem with this bill going and taking away that immunity?
Well, I'm not entirely sure that's true with respect to 571B, but I think the point that I would make is that if you're going to have a standard that applies in the K through 12 context, it needs to be fully consistent, right, with the obscenity standard. And so one example, as I noted before, this isn't limited to sexual conduct. It in fact goes beyond that. This is not fully consistent with the local community standards because there is a State Board of Education component to it. I don't know what the standard of review is for the State Board of Education. Are they looking at state standards, local standards? Typically, when we think about obscenity, we think about local standards because community standards evolve and change. That, to me, is not particularly clear in this legislation, especially given the fact that there is state board review. I would encourage this committee to remove that because I think that is problematic.
Representative Woodcock?
Thank you, Madam Chair. Good afternoon, and thank you for
Thank
taking
you,
my question.
Representative.
I'd like to go back to 571B because I know absolutely nothing about it. That statute would that encompass as well, private schools, parochial schools, any school, including public? Or is that, and cause you're talking about the New
Yeah.
Hampshire statute,
Yeah.
and this bill deals with, specifically with K-12 public schools, and it exempts parochial, exempts charter, exempts any other school. So I'm trying to find out if 571, is there a conflict there, or is
Yeah.
it crossover there, if I may?
I think it's a great question. I do want to check on that to confirm the applicability of 571B to K through 12 and higher education schools, because I do understand one of the intent behind this is to change the criminal obscenity law to kind of exclude K through 12. And it does so not by amending 571B, but by amending 654. The point why I want to make there with respect to that change in section 1 is that would, I think, include K through 12 private schools too, right? Because all you're doing there is calling out higher education. But with respect to whether 571B has an exemption for schools currently, I want to check, and I can get back to the committee on that. I don't want to misstate anything with respect to its application.
Thank you, Madam Chair.
Any other questions? Representative Kluger.
Thank you, Madam Chair. Thank you for taking my question.
Thank you.
I just wanted to clarify with you where it says second on page 2 that school districts would are required to have 14 days of notice for curriculum course material. So I'm making an assumption here that this would not include textbooks that are used, for example, for health class related purposes. Am I reading that correctly?
It depends on whether someone views the contents of those materials as satisfying the definitions. So that might be the intent, and if that is the intent to exclude that, I would certainly be clear about it in the legislation.
Follow up?
Sure.
Because it also mentions here that school boards are required to require that their schools provide developmentally appropriate collection of instructional resources.
Yeah.
So I'm assuming that that protects textbooks in that sense.
I hope so. I think I think that's the question, right?
Yes.
Do these 4 elements, the standards articulated in this bill, provide protections for that material, or is the wording here problematic to the extent that it could be argued that it's not covered? And that's why clarity here is so clear, and why making sure that these standards modify to the letter the constitutional standards is so important. So for example, nudity should not be the standard. It should be consistent with current law, right? It should be sexual conduct. That's one way to try to make this clearer to prevent that type of interpretation. And so we're more consistent with the constitutional standards that exist.
Thank you.
Representative Murray.
Thank you, Madam Chair, and thank you for taking my question. So with regard to higher ed institutions, do we see that there are potentially some issues around the constitutionality of challenging materials at an institution of higher ed?
So now I think you're referring to part 1, which kind of is, I think that's a good question. I do think it seems like what part 1 is designed to do is maintain the protections that exist under the criminal obscenity statute for higher ed. So I want to just kind of recognize that I think is what the intent is, and I think the purpose is to limit that current exemption under criminal obscenity law to the K through 12 context. I do think, right, when you start engaging in restrictions certainly above the K through 12 context, what I don't think is the intent here. Certainly the constitutional standards change, right? And the standards, change. So I'll just leave it at that.
Any other questions? Seeing none, thank you.
Thank you, Madam Chair, and thank you for the accommodation.
Sure.
I really appreciate it.
You're welcome. Representative Corzine.
Good afternoon. My name is Lori Corzine. I am a state rep from Coast District 7. I just wanted to talk about a couple of things. When we send our kids to K through 12 to their public school, those kids don't have a choice most of the time. So we need to go out of our way to make sure that families are okay with that. I've done foster and adoptive care for 20 years, well, 15 in Mass and then some here. Books that this bill wishes to address have really triggering effects on some of the kids in foster and adoptive care. The last I checked, 3 in 1 females were sexually abused in New Hampshire. I think it was 3 out of 5, 1 out of 5 boys are sexually abused. When a parent sends their kids to public school, they want to know that when their kids are in a public library, they're safe. They're not looking at things that are going to be triggering. This happened to one of my sons. We need to be careful of what we're putting in our public schools. Our numbers are dropping. We need to reach out and make sure these parents know that public schools are okay to send your kids to. We need legislation like this.
Thank you. Any questions? Seeing none, thank you. The Honorable Alicia Lekis.
Sorry, these are from books which are in our libraries. I thought they were just in our middle schools. When I passed these out last year, one of the reps said, "Oh, this is in our elementary school." So you might read this as even less than 10 years old. We're not talking about whether or not these are good books or not good books. In fact, the first one on here, Flamer, is actually a pretty good book for high school boys. It would be a terrible book for a 10-year-old. We don't need our 10-year-olds wondering if, when they go to Boy Scout camp in the summer, if they're going to have to come in a bottle, or if they should be considering suicide, which are topics in that book. And it's a well-written book. It says it's a graphic novel. It says the reading level is second grade, but it says the intended audience is 9th through 12th grade, not 9 through 12 years old, 9th through 12th grade. And yet it is in at least one of our elementary schools and many of our middle schools. The bottom one, genderqueer, which does have sexual activity in it for the definition one of the previous speakers mentioned, it's written for adults, not 10-year-olds. And the problem is these images, you can't get them out of your head once you've seen them. And I'm sorry I passed them around for you to see them, but I want you to see and understand. These are not the worst images out there. These are just ones I was willing to print. They get worse. This is, I'm trying to think of arguments people have had in the past. This is not an anti-homosexuality bill. I have numerous homosexual friends, good friends, and they have written many times, gays against groomers and leaving our children be innocent for as long as possible. And they very much object to this material being in our schools and our young children seeing this material. And you may say, well, parents can just,
go in and look? Well, no. Some school districts, yes. Some school districts, no. And I know of one, we had testimony of a dad who looked at the quote-unquote card catalog online and was relieved to find that his school didn't have any of these books. And then he went in to pick up his kid partway through school for a doctor's appointment or something, and popped by the library on the way. No, they weren't online listed. They were on full display as you enter the library as recommended reading. That dad took his kid out and never brought him back. And this is mild. Sorry, I could tell you what it was compared to, and I could tell you what state law for libraries is.
Thank you. Any questions? Seeing none, thank you. Oh, Representative Litchfield?
Thank you. And thank you for taking my question. What is the state law for the public libraries?
Well, it's federal, actually, and then it comes down to the state library, and it talks about not just sexual acts. It includes a vast variety of things, including books which are specifically to arouse, etc. I mean, it's a long, and I know that Rep. Cordelli has a copy of it. I did not bring that today, but I can send it if you need. And according to it, none of these books would be allowed. And the instructions are, if the state library gives funding to any library which has this type of material, then, if they give funding and then that library is found to have this type of material, they have to cut off funding for a few years. So I don't know if our state library gives any funding to our school libraries, but if they did, they would be in trouble.
Thank you. Any other questions? Representative Nadeau?
Thank you, Madam Chair. The gentleman from the ACLU stated RSA 571-B, and it does kind of specifically state some restrictions. Do you firmly believe that the law before us, the bill before us, will expand on that and protect the children in the libraries?
I think, if I recall, this bill was written partly towards the laws for libraries specifically, which is federal, which goes beyond the RSA that was stated there. And we follow those federal guidelines, laws.
Thank you, and thank you for coming before us.
Any other questions? Seeing none? Oh, one more. Representative Cornell?
I just wanted to clarify, I'm sorry, that the state library does not give any money to the school libraries.
That's cool. I'm glad. And I personally happen to think that the school libraries should follow the same rules the state library has to, but thank you.
Thank you. Jacqueline Benson.
Good afternoon. I have some written testimony that I will hand out real quick here. Jacqueline Benson, I am an author and a regional leader for Authors Against Book Bans. We are a coalition of writers, illustrators, and editors that oppose unconstitutional efforts to limit the freedom to read. And I'm here today to share some concerns about HB 324 as it's currently written. I'd like to point out that there is no existing definitive list of which books that have been published in the United States meet the legal definition of obscenity. So determining whether a challenged book is prurient or patently offensive or lacking in literary value, to use some of the language from HB 324, is always going to come down to a judgment call. And if we look at how those judgment calls are being made around the United States right now, you can see that among the most banned authors in last year's record-breaking 10,000 plus school library book bans were Margaret Atwood, Toni Morrison, Khaled Hosseini, Stephen King. And I think it's difficult to argue that titles like The Bluest Eye or The Handmaid's Tale, which are among the most influential books published in the 20th century, are pornographic and lack literary merit. So why are they being banned? Because too often the judgment call about a book's appropriateness or merit is being made by a single individual or body in a process that excludes other voices. A more robust and reasonable policy would see parental challenges reviewed by an informed group of stakeholders. That should include school administrators, but also librarians, school media specialists, teachers, school board members, and other parents from the community who are also impacted by these book removals. And in fact, a stakeholder-based approach is probably a legal necessity. Right now, 6 major book publishers and several best-selling authors are suing the state of Florida over a law very similar to this one as a violation of constitutional free speech rights. And that suit was recently green-lighted by a Florida federal court judge who called the state's approach capricious. So in conclusion, policies related to the removal of material from school libraries need to balance the legitimate concerns of individual parents against the constitutional rights of other students and parents in the community. And I would therefore urge the committee, if they're looking at establishing a precedent for this sort of policy, to make sure that it is a thoughtful and inclusive one that brings all the key stakeholders, including librarians themselves, who are the ones trained to assess the value of this material, to the table. Any questions?
Thank you. Representative Dry.
Thank you, and thank you for taking my question. I've always determined that banned book was one that no one could get a hold of. Is that what applies to these that you're calling banned books?
I don't think there's necessarily one single definition for banned book. As the Authors Against Book Bans looks at it, if a book is removed from a library and it is no longer available to students to read there, we would call that banned for those students. They would no longer have access to that book.
It says 2025, there's lots of ways to get access to books beside your local library.
There are, if you can afford them, if you have access, if you have transportation, if you have a budget. Part of the foundation of our libraries in this country was to ensure that access to information was free and available to every member of our communities.
Representative Litchfield.
Thank you, Madam Chair, and thank you for taking my question.
Sure.
Throwing this at you, probably not fair, but because you're an author, we had someone else that had testified how there are ratings on video games, there are ratings on movies. Even when you go to, let's say, a G movie, they might kind of pare down the highlights or previews of other movies to be more age appropriate. Why don't they do this for books?
It's a good question. I don't have an answer for that. I know as an author myself, I voluntarily put a content warning at the front of my own books that details any content people might find challenging or triggering or objectionable in the book so they can make a conscious decision about reading it. But there isn't an industry standard or a law that requires that kind of rating process. I can't answer for you why they haven't done that.
Thank you.
Okay.
Any other questions? Seeing none, thank you.
Thank you.
Catherine Gatcomb.
Thank you to the committee and the chairwoman for hearing me speak today. It's my first time testifying, so please excuse any ums or nervous hands. My name is Catherine Gatcomb. I am a resident of Durham. I have a master's degree in library and information science, and I am also a parent. I would urge this committee to vote inexpedient to legislate on this bill. As we have heard and seen, this bill is being introduced as a way to protect children. But what we have seen in other states with similar legislation is that this bill is censoring materials for children who may need them most. PEN America is an organization who tracks book challenges across the country. It was just mentioned there were over 10,000 last year. This was a 200% increase In those challenges, only 13% of them showed sex on the page. This could be a book written for teenagers. It could be a sex education book. But the majority of these titles are not that are objected to are not actually showing sex on the page. So I think that's important to keep in mind when we say obscene. You know, what does that really mean? And what it often becomes is books that are targeting LGBTQIA+ characters. And it is so important for children to see themselves in the books that they read. Books should be a mirror to your own experience. You know, children and teens, they're still learning about themselves, their identity. It is validating to see themselves in the books they read. And books also can be a window into the world around you. So children and teens, they are learning empathy. They are learning about the world around them, and we need to give them the resources to do so. As a librarian, you know, I've talked to families, children, teens, given them those resources. And I think for many kids, the school library is a lifeline, and books can really save their lives. As a librarian, we follow collection development policies, we read professional reviews, and we are trying to ensure that our collections are both age appropriate and relevant to the communities that we serve. It is absurd to think that any librarian, at least any librarian I know or have had the pleasure of working with, is out to harm children with the materials that we are providing to them in the schools. I think as a parent, certainly we have the right to guide our children in what they are reading and consuming, but it is not right for one parent to dictate what an entire school district is able to access. So with that being said, I urge you all to vote in expedient to legislate on this bill. Thank you.
Thank you. Representative Dry.
Thank you. Thank you for taking my question. I'm going to ask the same question here. You say it's represents a clear attempt at book banning. And do you consider banning just that some people can't do it, or just that no one can get it?
Yeah, I think I would echo the sentiments that were just shared, that when we use the term book ban, and maybe this is a divisive term that should be considered to say something else. It's attempted censorship. We are banning a child in that school's access to that book. That child can no longer access that book in the school. So in that sense, I would say, yes, this is a book ban.
Thank you.
Representative Morris.
Thank you, and thank you for taking my question. So, early in your testimony, you testified about certain children needing to be able to see certain material. I'm looking at a picture from a book, Genderqueer, where there's a male providing oral sex on another male, and I'm just wondering who in their right mind would need to see something like this at an age such as 10 years old?
To that specific book, I would say that book is an adult title. And I think that, as I mentioned, as librarians, we have collection development policies that clearly state, we look at professional reviews. That book has been reviewed for adults. It has won awards. And so, yeah, this is a renowned title for adults. And I think, to answer your question, should a 10-year-old read that book is not written for 10-year-olds. So I think that's how I would respond to your question. Thank you.
Follow-up?
So I take your answer to that is 10-year-olds should not be seeing that material.
I am saying that librarians follow collection development policy. Genderqueer is a book written for adults, and it is, as a librarian in my library, I did not have that book in my teen section of the public library. That is in the adult section.
That clarifies. Thank you.
Representative Litchfield.
Thank you, Madam Chair, and thank you for taking my question. So, if I heard you correctly, you mentioned that 13% of the 10,000 books were found sexually explicit. Do you realize that that is 1,300 books? And my question is, what is the organization? I'm sorry, I missed it.
Yeah, the organization is PEN America.
Could you spell just PEN?
It's PEN, PEN America. And again, that also included books about sex ed, stories. I mean, teenagers need to see their experiences on the page. Teenagers are maybe sexually active, and this is a safe way for them to understand their bodies. Again, I think it's all about that professional discretion of the librarian. This book is written for teens. I'm not suggesting that we put this in the hands of a first grader.
Thank you, and thank you for taking my question. But are you putting the opinion of the librarian over the opinion of the parent?
Oh, certainly not. As a parent, as I said, I believe that parents have the right to decide what a child is reading. If I don't want my child reading that book, then I will not allow them to read the book. But it's available. Yeah.
One more question.
I'm sorry, thank you. But we heard earlier today that, actually I was a co-sponsor on that bill, that the parents do not have access to what the children are taking out of the library. So how would the parent know?
I think it's about communication. I cannot speak for every parent and their relationship that they have with their child. And I think what I will say is that we need to rely on the professionals to look at these resources and review them. And not one parent should be able to take a book away from an entire group of people.
Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. It goes along with what you've been talking about. As a school librarian, if a parent had reason to be concerned about what their child was reading and send in a note and requesting, would you adhere to their wishes in terms of what their child could take out of the library?
Yeah, thank you for your question. I was not a school librarian. I was in a public library, so I can't speak to what a school librarian may or may not do. But I think that, again, it's about that relationship with your child and respecting, building that relationship and having an understanding of what they are or not reading. Yeah.
Representative Morse.
Thank you. Thank you for taking my question again. Based off your testimony when it comes to parental oversight with these books in their children's hands, currently there may not be any parental oversight with the current way that schools are run and their libraries are run. So it almost sounds to me like you'd be in favor of this bill because it would allow parental oversight, whereas currently there is none. Am I wrong?
No, that is incorrect, and I apologize if I have miscommunicated my sentiments on this topic. What I am saying is that as a parent, I can tell my daughter, she's 2, so we're reading Mooba La 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 right now, okay? But I can choose what my daughter is reading, and as she gets older, we can have conversations. But I do not feel it is right for one parent to dictate what an entire school board of entire school district is accessing.
Follow up.
So particular with the book I mentioned a little while ago, would you allow your 10-year-old to be able to read a book as such?
Respectfully, I don't think that is relevant to this. Thank you.
Any other questions? Seeing none, thank you.
Thank you for your time. I appreciate it.
Does that say Tasha? Are you sure? Pasha Roberts or Tasha? Oh, okay. Pasha, okay. Don't remember.
Okay, well, good morning. Honorable members of the Education Committee, and I am Pasha Roberts. I live in Wilmot, New Hampshire, and I'm on the board of 603 Equality, and I'm speaking today against HB 324. So proponents of this bill will be, and actually already are, parading cherry-picked extreme-sounding material before this committee today. Please do not mistake the forest for the trees. First, any child with a phone or internet connection can easily find any of this and more without having to go through the trouble of reading a book. The reason that these books are deemed dangerous is not their spicy scenes, but the narrative power of the stories inside of them. These controversial books, including genderqueer, are not stories about the pizza man coming to the house. These are coming-of-age stories with emotional nuance. They're companions for young adults as they navigate the difficult corridors of growing up in 2025. The books frankly walk through the life and challenges of real, raw people. By reading about them, a reader can decide whether they are or are not like these characters. I trust them to do that. Kids are smart. There is a moral panic around gender in this country. Young adults who question whether they are gay, lesbian, or transgender are particularly at risk of having every shred of affirming narrative removed from their libraries. I don't want them growing up in a desert as I did. In particular, as a sexual abuse survivor, I would have benefited tremendously by seeing material that described what I went through, even with the pictures that you don't like, that normalized it, took me out of isolation and gave me some insight about what I might do about it, what I might do next, how I might survive. Some of these books deemed obscene will be lifesavers for abused kids and accelerate their healing. Society will be better for it. That is their literary value. In other states, versions of this law have been used by small groups of individuals to prosecute a very narrow religious view onto public schools. A single aggrieved parent could use the vague, aggressive, prurient, bounty-hunting passages of HB 324 to cost the school district thousands of dollars, ruining the careers of well-meaning school personnel. It will lead to a chilling effect, overcompliance out of fear, and empty shelves. This is not freedom. This is not live free or die here. No good has ever come from censoring books. It might sound odd, but kids need these books. I emphatically encourage you to vote this bill ITL. Any questions?
Representative Dry.
Thank you, and thank you for answering this question. We had someone testify a few minutes ago about kids who have had traumatic experiences and this being a trigger for them instead. So I wonder how you balance those things.
Sure, thank you for the question. I am a survivor. I can tell you that if I saw something that I wouldn't find the book. I'd be looking for a book that tells me, what did somebody else go through? I mean, these books didn't start coming out until like the 80s. It was a desert. And as these books start coming out, it feeds you. You may, and I'm glad you don't understand. It means you haven't had to go through this. So congratulations. But if you've been through that kind of dark experience, it really makes a huge difference to actually see it, normalize it, understand, and know that you're not alone, because that's what the abusers do. They make you alone.
Representative Morse.
Thank you, Madam Chair. Thank you for taking my question. Similar to what Representative Dry said, as a sexual abuse survivor, first off, I just want to apologize for you having to go through that. I myself had the same situation happen a few different times in my history, and it does suck. Now, I was wondering how, in situations like you've mentioned, where books could have been beneficial for you in recovery, in essence.
Yeah.
Is there a specific book or instance that you had that helped you recover? Because for me, it had the opposite effect.
I mean, the first book that really, you might not be able to tell, but I'm a little old, so these books didn't exist. I mean, the first book that really I came into was The Courage to Heal, which came out in 1988, which is, well after I came out of school. If I had found that, wow, and there's still very few books for male survivors, so having material on that in particular would have been amazing.
Any other questions? Seeing none, thank you.
Okay, thank you.
Mackenzie West.
Hello, members of the committee. My name is Mackenzie West, and I am here to speak against House Bill 324. Under the rather confusing language of this bill, it amounts to a book ban that financially incentivizes parents to attack public education and school resources that are already stretched thin. Under this bill, parents will have the ability to challenge book selections available in public schools to further prudish and religious interest against the will of the majority. This bill aims to be a solution to a problem that does not verifiably exist en masse. Since when does a school library carry books that are inappropriate for the target demographic? The truth of the matter is they do not, and that is already accomplished through the underpaid and underappreciated work of school librarians and administrators. What this bill aims to do is, in part, target queer people, to say that our existence is inherently and falsely sexual, and therefore deemed inappropriate for school children. As a trans woman and a lesbian, is my experience inherently inappropriate? Many proponents of this bill, and the ones like it, would argue yes, even though my experience is no more explicit or inappropriate than any cishet experience. Those proponents seek to erase similar stories to mine so that they can erase people like me. It signals an early stage of genocide, and in the end, it protects no one. What are the kids to learn when we blind them to ignorance and darkness, and how do we prepare them for the world when we only tell them sanitized stories that don't cover the experiences of a varied population? I hope that we don't let ignorance and darkness win, and I urge you to vote ITL on House Bill 324.
Thank you. Any questions? Seeing none. Thank you very much. AJ Coletti.
Hello. I think I wrote 2 minutes on the thing, but if you're giving people more, I'll take it. So I actually wrote this in preparation, I guess. Seems to me that the government's motive behind attempting to address these kinds of impressionistic issues into neatly laid out objective regulations is very plainly an ongoing effort to create a common enemy among a group of people who they pretend to sympathize with, the average everyday Americans or the silent majority. But really, we working class families haven't a single reason not to unite. As human beings, I think we all want to protect our children, as seen in the current constitutional protections in place prohibiting obscene material for minors. So, in such a time of genuine countrywide turmoil, the attention being given to these kinds of bills all across the nation translates to me like needless pot stirring. We all think showing kids inappropriate content's no good, but we literally can't even afford groceries right now. Why, during a legitimate crisis, are we choosing to fight culture wars instead of getting all hands on deck to improve our most dire struggles for things like housing and food? Not only are we being fooled into becoming more divided with this crap, and distracted from our biggest problems, but I feel like it's pretty dumb for politicians to try and codify a paradigm into law. And this goes for any sort of paradigm. Doesn't matter if it's bigoted or not. It just doesn't work to address emotionally charged right brain issues with a strong-armed left brain regime that only sees everything in black and white. Legal definitions function the most properly when they concern unquestionable facts and are straightforward, such as murder. A person often clearly appears either dead or alive. You know what kind of stuff I think is less clear of an ultimate legal definition? Words like inappropriate and artistic and shameful, like that's in the bill or whatever. I mean, just take the sentence in the bill. It goes, if the material lacks serious literary, scientific, medical, artistic, or political value for minors, then it can be considered harmful. Each person defines something's value differently, especially artistic or political value. Not to mention the way serious is thrown in there. How is one to define on an objective basis the meaning of serious value? The whole thing just reeks of personal bias. If I were you, I would be very questionable of all this. All right. And then when the person was introducing this bill, they were using words like pornographic and graphic to describe. I think they said like some kid was reading a pornographic book and they asked for a graphic copy, or the library asked if they want a graphic copy. Be a little bit more specific with your language. I don't understand this ambiguity and the vagueness. Again, when sorry, no, I can't do that. I learned I can't do that. Earlier in your testimony, you mentioned a certain group of people who need to see a certain kind of material. Again, why are we not being specific here? It feels like we're purposefully hiding behind this, like, professional, formal, in the name of public safety sounding rhetoric, when in reality, we're doing unconstitutional things that are not okay. Just me, but I don't know. Also, what X or R-rated movies are being shown in schools? What schools have Playboy magazines in their libraries? Come on, people. Why do you think numbers are dropping in the public ed system? It's terribly funded, and it's the government fault it sucks, not teachers. I could keep going. All right. I'm done though, right? That was the timer. That was 3. All right. I think I made a point, right? Oh wait, do you guys have questions?
Does anybody have any questions? Representative Woodcock?
Gosh, I wish I heard the whole thing. I didn't catch where you were from.
I'm from Goffstown.
Okay, thank you.
Yeah. Yeah, of course. I do. Cool. All right. Thanks. Thanks, guys. I've been here a lot this week.
Betsy Harrington.
I'm 19, by the way.
Hi, my name is Betsy Harrington. I'm from Deering. I have 2 kids who attend Hillsborough Deering High School. I'm here to represent the reality of what is being presented to kids in public schools. I've worked as a sex offender counselor at the state prison, so I'm well aware of what tools are used to groom and offend our children. 4 years ago, my freshman son first showed me inappropriate library content that was being promoted to his buddy through his school Chromebook. He was sent to the principal for reading it out loud. The principal agreed it was inappropriate, but just sent him to his next class. Nothing was ever done about the presence of the inappropriate content. So I decided to look at his school's online library app called Sora for myself. I was absolutely shocked at what I saw. It wasn't just age-inappropriate content, but I witnessed it privately connecting our children to sex-seeking adults through their school Chromebooks. Let me explain. The book titled This Book is Gay by Juno Dawson is widely available in the Sora Student Library Shared New Hampshire online collection. The book has working hyperlinks to Match.com in the part of the book entitled How Sex Apps Work. It then goes on to explain what is wanted and expected from who they meet up with. It tells them how to perform every possible sex act, including acts I, as a sex offender, have never heard of. It blatantly gives sex misinformation. Linking kids to sex-seeking adults already has a name. We call it sex trafficking. The problem of age-inappropriate content in our schools is very real. Our kids are in actual danger if we don't rein in the liberties that some of these organizations are taking with our kids. Some boundaries need to be set here. When I first brought up the issue with my school board privately, they banned my children from using all school libraries as their solution. That was 4 years ago. Banning top students from using school libraries won't solve this problem. Promoting age-inappropriate content to school children isn't right no matter how you present it. It's undeniably inappropriate. We need a system that weeds out the legitimately dangerous age-inappropriate books in our school libraries. We wouldn't allow penthouse stories to be an option, yet the book I've been describing is exponentially worse than any penthouse story. I'm aware of a disturbing incident that occurred at Kearsarge High School during their recent deliberative session. Taxpayers were put into the library as an overflow space. A parent randomly picked up a book and opened it to a picture of an actual orgy. A scene of an undressed man sitting in a chair with a woman on her knees, bent before him, head between his legs, with 2 other women at his sides with his fingers in their mouths. She showed the book, Saga Series Book 4, to others in the crowd, including the police. The book was ultimately removed. I think everyone can agree pictures of orgies are inappropriate for school libraries. Taxpayers don't want to pay for over-sexualizing kids. They'd rather protect them. Please see the necessity of this bill and vote to support it. I'm happy to answer any questions, and I hope I get the opportunity to show you. I have the Sora app right here on my phone, ready to show you exactly what I mean.
Thank you. Are there any questions? Representative Litchfield.
Thank you, Madam Chair. Thank you for taking my question. Could you please repeat to me the name of the app?
Sora, S-O-R-A. It's widely available. It's not available in every public school, but it's widely available. And there is a shared collection called the New Hampshire Shared Collection. And this book with that sex trafficking link is in it. So it's literally widely available to thousands of high school students around our state, and could be other schools besides high school. I know the way it's put in the Sora app that it should be just for high school students if the librarian is doing their job.
Representative Hall.
Madam Chair, thank you for taking my question. So that story was 4 years ago, this app, right? 4 years ago.
No, my kids haven't used the library since then.
So you don't know if that's still happening?
It was still there. I have the app. So my kids aren't allowed to use it. So I have it on my phone here so I can show you. I have it open on my phone right now. This book is gay.
and I can show you the hyperlink.
But my question, the question, follow-up question? Follow-up, okay, thank you. Is that schools have filters. I mean, you're sure right now the school can access that link. Every kid in the state of New Hampshire can access that link, or some kids. I mean, do you have proof that that's the case?
So any school can add or subtract a book from this app, so they can make it for their, used best for their own school. It comes free. It's $250 to get over 8,000 books. So that book comes free with that New Hampshire shared collection that everyone who gets SORA gets that in New Hampshire. So it is available.
Yeah, no.
The librarian would have to remove that book because it automatically comes free with that library.
One more follow-up, please.
Sure.
Okay. The question is, all students in the state of New Hampshire, if that, whatever that app is, they can click on those links and get live action or whatever you're talking about.
Any student that has the SORA app, their librarian could remove this book. So my librarian has not, it's available to my kids. But any child that uses the SORA app could use that. They take the book out, just like I have it right here. I can show you because it's my kid's account. And they can link to Match.com in the part of the book that says how sex apps work. That's sex trafficking. I was a sex offender counselor. I know what it means. We need this.
Any other questions? Seeing none, thank you.
Thank you.
Anne Marie Banfield.
Good afternoon. For the record, Anne Marie Banfield. I'm a parental rights advocate, education researcher focused on academic excellence in education. I think we're starting to hear why so many families are leaving the public schools. So stopitnow.org is an organization that's directed towards stopping sexual abuse in children. And if you go to that website, there is a portion that says when you hand children pornographic or obscene materials, it's considered child sexual abuse. So that's the part that I'm going to talk about. I get that there are subjective books in the library, and when I get a call from a parent about something like that, my advice to them is, I think that there's books that we don't like, gonna have to get over it. And then there's where you cross a line. Mm-hmm. And we're seeing when you're crossing a line. And that's pornography, obscenity, when you are crossing a line, when you can't listen in the chambers to what the representative's reading, we're crossing a line. And they define it as child sexual abuse. I do think that there should be transparency. I don't think that this bill probably goes far enough. I do support it, but I would like to see more transparency so parents can get more involved. Because I think when parents are more involved and can see this, they're not quite as likely to run from the school or pull their kids out of the school. That now they feel like at least you're working with me. And so you can opt out of objectionable materials in school. And again, I don't want the objectionable materials in the same category. But, the Supreme Court Justice Potter Stewart, was asked to describe his test for obscenity in 1964. And he said, "I know it when I see it." I think we all know it when we see it. Picture of two males engaged in oral sex. And I don't care if it's two males or a male and a female. I mean, making this about the LGBTQ community, it doesn't matter. It could be heterosexual. There is a line. And when you cross over it, that's where I think that this bill is trying to go. Let's stop where you're crossing over that line. Or at least let's have a parent be part of a process to logically and make an argument as why this is harmful to children. I've never seen a parent take a biology book to a school board and say this is inappropriate when they're trying to teach biology. I don't know about you, but I haven't seen it. You're also asking taxpayers to pay for this. And that's why I look for things like, how can we come together on this? How can we find a way to address this issue that's driving some families out of the public schools? I mean, you're against EFAs or you're for EFAs, and then when you set these situations up that drive parents out, I'm like, can we find something that keeps them in the school where they don't have to pull their kids out because it's not family friendly? These books, I'm sorry, I think are used to also groom children. That's all I have to say.
Are there any questions? Representative Litchfield?
Thank you, Madam Chair, and thank you for taking my question. My question is, we had another representative bring up questioning, had it been several years since there were issues with these books. I know as a child advocate, you get calls. I don't know how often you get them. When was the most recent call you received, or have you received in the past 6 months or years? Is this an older problem that's kind of resolving itself, or is this ongoing?
I think what you're experiencing is people giving up. I think what you're experiencing is people saying, I'm not going to bother going to my school board because they don't listen to me, or my schools, and they don't listen to me, so they just pull their kids out. And so when you hear less and less, and yes, I do hear from parents still. Yes, I certainly do. But what happens is after a while, people just, you have a school choice. You can now make that decision to pull your kids out and go somewhere else. We have ratings. I think it was you that asked about the ratings on movies and things like that. That's very parent friendly. I can look at a movie. When my son was growing up, he had a friend that would come over, and his parents said the boy wasn't allowed to watch or read Harry Potter books. My son read Harry Potter books, but he didn't pull them out and give them to his son. It's called respect. I respected her. We had a difference of opinion, but it's like, we need to show some parents respect. That means making things transparent so parents can be involved, and then they're not having to remove their kids. But yes, it's still going on. It's still going on. I just think that things sometimes die down. I see it in other areas, getting people to come out and speak before you. I've given up. I've taken my kid out. Why would I even bother coming here?
Any other questions?
Thank you. Thank you for your time.
Cindy Bennett?
Hello, Cindy Bennett from Raymond, and this is my first time speaking to a committee, so thank you for, this is a very big privilege that we have to share and to have free speech, so I really appreciate this honor. I'm coming here in favor of this bill. I'm from Raymond. I'm a mother of 13. I'm also a teacher. I have become a school board member and a library trustee. I am here to support this bill and ask you to vote in favor of it. Back when I was a kid, this bill wouldn't have been a thing, since it was agreed on by society that pornographic images are harmful to children and should be hidden from them. I can remember even brown paper on magazines at the grocery stores. Fast forward to when, I don't know, but I can tell you I began to hear things in 2020 especially that were very disturbing, and about content leaking into schools that is inappropriate. I thought, not in New Hampshire. New Hampshire's safe. In July 2021, I went to a board meeting at the Timberlane District on invitation of a friend, and my ears and eyes were shocked. This was July 15th, 2021 at the Performing Arts Center in Plastow. I have some of this meeting recorded on my phone. I also have the minutes printed to share the information I heard. Some of the discussion was about mask wearing, and some of the information I did not expect to hear. There were parents there that were upset that 22 children were chosen by some teachers to form a club with kids, and kids were told not to tell their parents. The parents found out a few weeks after the club started and were enraged. They came to this meeting and read some of the content the kids were exposed to. Police hating, negativity to first responders, and sexual content materials. I was not only shocked by what the parents were saying, but I was also shocked by some of the board members' attitudes and reactions to the content. Some of the board members were quite disrespectful to the very parents who had been deceived by these actions. Some of the school board members actually argued when asked to investigate this matter further. I have video video of their reactions. I did not keep up with the follow-through on this day, but it did open my eyes to the possibility of the problems we might have throughout New Hampshire public schools. The fact is, inappropriate content was presented to children without the parents' knowledge. Parents should never have to fear that the school is doing anything to harm children, and especially behind their back. This can and is happening in New Hampshire. I also know from hearing rumblings around my town that parents don't want to step up against these types of things for fear that their kids might be treated badly because of it. Of course, parents don't want their kids to be treated badly because they are trying to protect all of the children. I support this bill because it brings back to the forefront that parents are to be respected as their child's protection, and nothing should be happening in the school that will harm children, and anything of pornographic nature will be dealt with in a strong and intentional manner with the child's safety at utmost importance. My question to you is, isn't there enough information for children to study without resorting to sexual content that is not appropriate for children? Kids are in school to exercise their brains and to learn how to learn, to be educated in reading, writing, and arithmetic. Stay in that lane and the kids will be fine.
Thank you. Are there any questions? Seeing none? Thank you, Representative Ratz.
I wanted to answer a couple questions. Thank you.
Kevin Gagnon?
Good afternoon. I want to start by saying I'm in support of HB 324 before I run out of time. Dear honorable members of the New Hampshire Education Committee, my name is Kevin Gagnon. I'm a widowed single parent of 2 children attending the SAU 57 public school system in Salem, New Hampshire. In the fall of 2021, I discovered a story of a parent verbalizing the words and details of an obscene book readily available to minor students in front of her local school board in another state. Her description of the contents of the book was so graphic and vulgar that the board asked her to stop speaking and was told there are children at the meeting. Seems that her point was made. Pornography is not education. I immediately wondered, could obscene materials be here in Salem, New Hampshire, schools and libraries? Getting to the answers to these questions was not easy, and certainly an eye-opener. I feel that these obscene books are often made easily accessible to minors, but not adults. Also, to not judge a book by its cover, but by the content and lack of moral character. The discovery of obscene materials available to minors here in Salem, New Hampshire, led to finding similar contradictions within the SAU 57 administration policies. Policy EHAA regarding technology responsible use states, obscenity is illegal and not tolerated. Obscenity generally includes, but is not limited to, sexually explicit or pornographic content, a sexually offensive word, or combination of words potentially, profanity, swearing, or an expression or content, including lewd images. Questions about obscenity should be directed to the school administrator. Consequences for violating enforcement of this policy requires community support. Student, faculty, or staff that become aware of violation of any portion of this policy must immediately notify their building administrator. The building administrator will then notify the director of IT. Violation of any portion of this policy can result in loss of access and may result in additional disciplinary or legal action. Boy, that's so fast. Just as I feared. All right, guys, booklooks.org. Put that in your notes, because I heard other people, and just give me a minute, please, because I've been working on this for like 3-4 years. I'm a parent, all right? And I do this by myself, and I'm really tired of the inappropriate nature of what we are battling. To some of these wonderful speakers before me pointed out that this is absurd. When I was a young person in school, I went into my library. I'm just going to go off the cuff here. When I went to my library, the extent of this type of concern as a parent was a National Geographic magazine with a woman breastfeeding her child. And yet, yeah, I might have snickered or whatever with my kids, but the point is, it's got changed quite a bit in 35, 40 years, okay? There's a serious problem, and that's what I was going to get to. I've gone to the school board 2-3 times. I removed my son from the school. To somebody's point here, Miss Anne-Marie Banfield, she's absolutely right. I pulled my kid from the school, and he begged me to take him back to the public school for his Christmas wish. All right? That's all he wanted for Christmas. And I worked my butt off driving him back and forth from Salem to Newton, New Hampshire for a nice charter school that, doesn't play games with this type of stuff. Back to other speakers' point. When it comes to education, this is an education committee. Can we not all agree? Math, English, science, reading, history. That's all the kids need to know about. And I'm sorry, when it comes to sex, I'm old-fashioned. My late wife would have called me a prude, right? But I believe that that's something that any human being, insects, animals, etc., you don't need an education on that, right? When we go into the woods of New Hampshire, you think the deer and the moose need an education on that? No.
Kevin, do you have testimony that you could leave with us?
I could send it in an email.
Okay.
In full disclosure, I'm just repeating what I said last time when Glenn graciously introduced this bill. And actually, I couldn't make it here because I'm pretty busy at home. And I asked Representative Valerie McDonald from my town to read it for me, but because she was green at her position, she went out of order and was unable to complete my testimony.
Are you willing to take questions?
I absolutely would love questions. Bring them.
Is there any questions? Seeing none.
Oh, come on, guys.
Thank you.
Drove all the way from Salem.
But you can email your testimony in.
Yeah, let's bring sanity back to education, please. Thank you.
You can give them that piece right there.
Yeah.
This one?
Mm-hmm.
It's kind of chalked up with notes, rather.
It's fine.
I'll get to you. Yeah.
Therese Bostroff.
Thank you for your time. Sorry.
Therese Bastarash, Loudon, New Hampshire. Thank you for your time. I know it's been a long day for you guys. I'm going to go quickly. This was brought to my attention a couple of years ago, and I too have 2 children that I adopted that have been sexually abused, and we are trying to teach them what is normal and what is not normal. We do not need to normalize abuse. That is not how you help a victim. They need to know what happened to them was not okay so that they don't recycle those behaviors. That being said, when this was first brought to my attention, I quickly said, what is the New Hampshire law on child pornography? Children in sex acts. And if you look at 649A:3, it is anything that is to buy, procure, possess of a child engaging in sexually explicit conduct. It is a Class A felony. I brought that straight to Frank Edelblum and I said, how is this not a felony that we have a child who's giving oral sex to an adult in our public school? If I'm caught with this material, it's a Class A felony. And he said, Therese, you're absolutely right. But there's some sort of exemption for school libraries. But they're not accountable to 649A:3. There's your language. And I said, that has got to change. If any of us is caught with this material, it's a Class A felony. A child giving an adult oral sex, a child in a sex act, buy, procure, possess of a child engaging in sexually explicit conduct. The language is very clear. It is not ambiguous. Why there would ever be an exemption and this material to be allowed in an elementary public school when my husband and I, between the business and my job, which I'll probably be late for, are spending $40,000 a year in taxes to the state. We want reading, writing, and arithmetic. You leave the parenting to the parents. And how dare you even consider something that would be a Class A felony to be allowed are hyperlinks to Match.com. I ask each and every one of you, you have been elected to do a great job at $100 a year. I am so grateful for your civic duty. Please do right by my two boys. I'm doing my best to raise them up in the way they should go. And I need your help to make sure they're safe when they go to their public school. Thank you for your time.
Thank you. Are there any questions? Seeing none. Thank you. Is there anyone else who wishes to speak on this bill? We'll close the hearing on HB 324.